All right. Good morning. It's 9 o'clock, and I'm going to call the meeting to order. The Board of Examiners for Land Surveyors. Notice of the April 6th meeting, April 6, 2016 meeting of the Board of Examiners for Land Surveyors was posted to the Board of Examiners Land Surveyors website on March 21st, 2016. Take a look at, well, first, welcome to all of you that are here first time or several times or however many times you coming to be with us, and we will get to the things that we need to. I'd like to take a look at the agenda and make a few changes in the order of things in the agenda, if that's all right. I'd like to put the review of applications further down and probably near the end of our meeting. I'd like to have our legal report and all our other reports, the director's report, et cetera, to begin with, and then we'll take up the review of applications. Hold up anybody from doing whatever everybody else needs to be doing. If that's so. Second. Any other discussion? All in favor? Aye. Okay. Well, now that we have done that and we've adopted the agenda, I think that I would like to review the minutes. Are there any additions or corrections?
I'll make a motion, Mr. Chairman, that we approve the minutes as written and submitted.
Motion's been made.
Second.
Seconded. Any other discussion concerning the previous meeting's minutes? Favor?
Aye.
Opposed? Likewise. All right. Minutes have been. Okay. I think I'm going to go to our legal report first because I don't want to hold Mr. Green up. Are you going to be here with us the whole time?
Yes, sir.
Oh, well, in that case.
I'm yours all day, Mr. Chairman.
Sorry.
I'm so
Our condolences, Mr. Green.
And in that case, I still will start with the legal report.
Okay.
So let's begin with that.
Okay, well, first of all, my name is Mark Green. For those I didn't have an opportunity to go introduce myself to personally, I'm Chief Counsel for the Division of Regulatory Boards, and I'm going to be serving as your legal counsel for this meeting. Sitting to my right is Miss Laura Martin, who's an attorney with our office, and she is going forward going to be your permanent assistant general counsel who will serve as your legal counsel going forward. Miss Martin has been with our department for about 15 months, has been working with some other departments and has stepped up and taken the land surveyors as well as the board of contractors, and we'll be working with you closely in the upcoming hopefully years. So she's going to assist me today and be here with me also, but we will, in fact, I'm going to ask her if she is ready to go ahead and present the legal report to you.
Legal report is on the iPads. If you just on your agenda tap the legal report, it'll take you directly to the legal report. Just tap the word legal report on the agenda and it'll take you straight to it.
Good morning. I'm of the understanding that you like the legal report read into the record, so I'm going to go ahead and do that unless you want to do that a different way. Okay. So we have case L16-SUR-RBS 2016008-701. Respondent has no complaint history. This was a consumer complaint that was received alleging a boundary dispute in an estate settlement involving 3 heirs. Respondent was appointed by the court as a commissioner for the purpose of partitioning property of said estate, which involved a total of 109 acres and a home with mold. Respondent was one of 3 commissioners appointed by the estate, along with a licensed appraiser and another licensed land surveyor. Respondent, in his capacity of court-appointed commissioner, was not acting as a land surveyor, nor did he perform a survey. Additionally, the complainant has since asked that this complaint be dismissed as the disputed matters have been resolved. Our recommendation is to dismiss this complaint.
Question concerning this particular,
No, it sounds pretty straightforward to me.
okay? Accept the legal department's recommendation.
So
Second.
All right. Made and seconded. Any other discussion? And all in favor of accepting the legal department's recommendation? Opposed? All right, we accept that one.
Second item on the legal report,
I
sorry.
did not get a copy of that on the second item. I guess it's probably on the iPad. The young lady asked if we had an amended legal report. I did not receive one.
It's on the iPad.
yeah, I think this is the one that's on here.
Well, I would like a paper copy if I could,
I have
if there's
Mr.
one
Wakefield.
available. Thank you,
It's
Mr.
the
Green.
paper copy, the paper copy has the names on it.
This one does not.
Oh, okay.
Check the second page.
I took them back.
1 minute now.
This is case number L15-SUR-RBS 20150217461. Respondent has had one complaint, which was dismissed in 2010. This complaint was received after the complainant had obtained a civil judgment of $10,000 against landowners who used the respondent to survey land and determine the boundary lines between their and the complainant's property. Complainant was out of town, and when he returned home, he found lumber had been harvested from his land without his approval or knowledge. Defendants based their conclusion of where the boundary line was based on respondent's survey, which was shown to be erroneously done in court. Respondent ignored a natural monument called for in complainant's deed and instead used text maps to determine the boundary and ignored an old fence row. Complainant's expert witness and surveyors in court testified about the deficiencies in the respondent's survey, and the court found in the complainant's favor. Respondent was not a named defendant in the matter, but the record shows that his survey was improperly conducted, which led to damages against the complainant. The original decision was to authorize a formal hearing and send a consent order with a civil penalty in the amount of $1,000 in addition to $1,000 in addition to a voluntary suspension of the license until such time as the respondent could show proof that he had attended 16 hours of continuing education courses in boundary surveys or boundary law from the approved list of courses and providers as approved by the board. Also, a letter was to be issued to the Register of Deeds in respondent's home county informing them of the respondent's suspension. An updated and new recommendation. This matter is now being represented because though there was a court order in the civil proceeding related to this matter, it was not sent per the normal operating procedures to the board expert reviewer for an opinion. Accordingly, it is legal's recommendation that the board wait until proceeding with its previous decision until the independent review can be conducted and that recommendation can be given.
One that we heard last meeting.
Correct,
that
Mr.
I
Chairman.
Talked to you about because I felt like that we had not gone through normal protocol for the board, and so that process has now been started. So,
We have not submitted it to the reviewer. We were waiting for the board's approval, but then we will, depending on the board's approval.
okay,
And after review, Mr. Chairman, after I took a look at it, to me, it seemed appropriate that even though the court order says what it says, and it may be, our reviewer may 100% agree with what the order says,
Right.
it should go through our reviewer, through our normal process before we bring it to the board, and that's why I believe we should represent it, so.
Thank you for doing that, and after our discussion, I certainly felt the same way, because we had discussed that here and determined that it had not gone through that. So now we want the board's approval to go through the normal protocol that we've, which complaints would normally do when they come into your office.
Correct.
Okay? Any discussion? You guys have any questions? Sue, anybody?
No questions. I think it's the right course of action here. I certainly want to give the respondent every opportunity in due course of the process and make sure it goes through the right.
Are you making that in form of motion, Mr. Kaufman?
I can do that.
Okay,
So moved.
okay, and I'll second Mr. Kaufman's motion.
Okay, any further discussion? Okay, all in favor?
Aye.
Okay, so that will go to you, and then
We will have it
on-
sent out
on
to
that point.
review.
Okay,
Does that conclude your legal report at this
Yeah,
time?
yes.
I have some other legal questions, if I may.
Sure,
Since you're new to us and we're new to you.
absolutely.
So forth. We've had some dangling things out there, and I wanted to kind of, since we've had a change, sort of, let's get caught up to speed per se.
Okay,
The matter that we just handled is an example of our complaint process, and I just wonder if the legal department is now going to just use the reviewer process completely as the method of doing it always, or will you continue to review in the department case-by-case basis to determine whether or not it should go to the reviewer? The reason I asked that question is we had two cases just presented. It seems to me that case number one that was presented was probably decided by the legal department. Now, that's just an assumption on my part. Case number two was probably an error that was made previously, but it rose to the level that it needed to go to the reviewer. So my question is, are we still apples and oranges, or are we going to go reviewer across the board?
well, I don't, most instances, I mean, from what I've done in other programs, I take it on a case-by-case basis. Some obviously need to go to an expert reviewer because legal doesn't have the expertise to be able to say this is outside the standards of practice, or this is a matter that really only a professional land surveyor, expert engineer, whatever, can determine. So those would always, it would be mine and Ms. Martin's, intent, I think, to always send those to a reviewer. In some, like the first instance, I wouldn't necessarily, it wouldn't be my practice normally to send that to a reviewer if it was obvious that, for example, in this case, somebody was operating under a court order, wasn't really operating as a land surveyor, and the complainant had said, we have resolved the matter, then I might, make a recommendation without sending to the reviewer. However, if there are professional standards involved, or if there are questions about, practice and different, applications of land surveying techniques, there's no way, and I think I can speak for Ms. Martin, that either her nor I can make a determination as to whether there's been a violation.
So, this is not a challenge to how you do your job. I
Sure,
know, please don't misunderstand, but this is sort of the normal conversation I like to have when we get a new face on
Sure.
that side of the table, just to kind of have a feel, because, for example, we have many cases that will probably come to you over time that are relative to maybe a surveyor charging too much, or maybe a boundary dispute, or some things that are not within that other parameter that you're talking about that maybe reviewers should view. And I just wanted to kind of know your flavor, and hopefully Ms. Martin's flavor, as to how you would probably approach those. And you basically answered the question the way I expected you to, which is good.
Okay.
Which is good. I didn't want to be operating under a new set of rules and not know about it, if that makes any sense.
Sure, I understand. And I think from our perspective, if there's any question whether or not there are technical matters that need to be reviewed, we're going to send that to a reviewer. And it would be my philosophy to err on the side of caution, and if it's close, we go ahead and send it to a reviewer. And so that would, and I think Ms. Martin and I would agree with proceeding with the complaints like that.
I got a couple others, if that's all right.
Yes, sir.
The previous attorney had been working on some GPS standards, global positioning
Okay.
standards. Now, I want to give you just a moment of history about that, if I can. In 2011, our standards of practice were rewritten and approved through the proper process, and that is now the current standards of practice that we operate under. And in those standards of practice, it stipulates, there's a couple areas in there, it stipulates that the board is to formulate a standard so that the profession can contact the board, either website, et cetera, and know what that standard is for that particular thing. The reason that the language in that standard section was written that way is because that particular technology is constantly advancing. I don't want to say moving target, but it's constantly advancing, and from time to time, the rules of the road change. Okay, and we chose a federal format that basically gave us a pretty well uniform standard that everybody across the United States would be working with for the most part. But we have been delinquent on this board since 2011 to get those standards in place for our licensees. For example, going back to the legal report, if today we had a complaint about a surveyor relative to GPS standards, it's my opinion that we would have some difficulty in disciplining that surveyor if they did do something egregious, okay? Because we have not crafted those standards. Well, over the process of the last couple of years, we've been trying to get there. But we have seemed to run into roadblocks, and when we run into those roadblocks, we now are at a situation to where the GPS standards are trying to be, if I am incorrect, they're trying to be considered as rules to be placed in our standards. And I personally don't like that. That's just a personal observation because of the way that the standards were set up and written. But that was the flavor that we had with the previous attorney. And we certainly, I think I can speak for the board, we certainly want to do things right. We want to make sure that, and obviously a rule is probably more defensible legally than a standard or a policy written by the board that applies to the rule. So what I'm trying to get at is this ball has been rolling around on this floor since 2011, and nobody's picked it up, basically. We're trying to, but we still haven't got our hands on it. And it's something that, it's in my opinion, that we need to get a grip on and get it done and move on. We got other things to work on.
Okay.
So, and like I say, I know that's totally new to you and Ms. Martin, and I understand that. Don't expect any kind of decision from you. But what I wanted to do is give you a little bit of history as best I could. And obviously my opinion that I think that our current standards tell us what we should do, but we're being directed to do it in a different way. And because of that, my heartburn is the rule process takes a long time. And it is what it is. I mean, it has procedure, it has routine as to how everything has to happen, but it just takes a long time. And I'm concerned about, and we've been fortunate, knock on wood, we've been fortunate. We've not had a complaint that's put us in a box in that corner. And then we couldn't defend ourselves as the board. So I'm worried about that. It's out there somewhere, and it's going to show up, and I don't want it to rear its ugly head before we get a grip on this, if that makes any sense.
Okay, I'm processing all this, and I've heard of some of this on the periphery, and of course I've never had a conversation with you, so it's difficult for me to get into a substantive discussion about that. But so that I want to make sure I'm clear, there were federal GPS standards that were passed in 2011.
No, the 2011 is our standards of practice for the state of Tennessee.
Okay,
And
okay.
let me just read that one sentence to you if I can find it here quick enough. Always, I can't put my finger on it. I didn't highlight it. I didn't know if we'd get to this today or not, so I didn't highlight it.
But that's the statement that says the
That's-
board shall
yes,
adopt.
Right. And there's another area in here too that says that also, and I'm just not putting my finger on it at the moment. I apologize, sir. Here it is. Okay, do I need to cite the rule and so forth?
No, you know, just-
I'll be glad to for
No,
that. But
that's
anyway,
fine.
basically it says, two sections here. It says static GPS surveys. The land surveyor must meet the current GPS standards as set by the board. And then the second one is RTK, real-time kinetic surveys, says the same thing.
Okay.
Standards as set by the board.
So the question is, standards as set by the board.
Right.
The process, is that a rule process? And as you're saying,
That's the current direction that we are, that's the road we've been taking down.
right, okay.
And if that's the road that we need to travel on, that's fine.
Then we need to get on it.
We need to get on it, and we need to get on down the
Right.
road.
Okay.
Before we have a problem, in my mind.
If the board will let me, obviously, I can't.
Oh, I didn't expect no.
I know, but
No, sir.
I would like to give you an answer, but I'm going to have to study, and Ms. Martin and I are going to take a look at this so that we can advise how best to do that. And if it's a rule, then we need to get on it. And, you know, rules don't necessarily have to take as long as sometimes they do. And so, you know, if that's the case, then we need to get on it. We need to be ready at the next meeting to get on it. And if not, if we have some other alternatives, then we need to get there too. And so we will be prepared to address that. And
The document I read from was revised in March 2011.
okay,
So what I can honestly tell you is, what I read from March 2011 to today, in April of 2016, we do not have that.
okay,
And I think 5 years is way beyond where we need to be
Right,
to
I
have
understand.
that. That's just my personal opinion.
and I understand that. Yes,
And, and I appreciate your willingness to listen to me about that.
Sure.
And your willingness to work with us to try to help get that resolved.
absolutely. We will be committed to getting that resolved.
Just a couple other things real quick, and I write all this stuff down and save it up. So when the new guy comes, I beat him up. You know?
There you go. That's all right.
But
I'm used to it.
I understand. But we still have an issue that is out there about, and I think if I remember correctly, the previous attorney was going to draft a letter to the Attorney General's office relative to what we call QBS, which is qualification-based services.
Did you ask the previous attorney to do that?
Yes, sir.
To make an attorney
Yes, sir,
general
and
request?
it is in the last legal report. I personally made the motion that it be drafted. Mr. Kaufman seconded the motion. It was unanimous by vote, and I assumed that we would be seeing that letter at this meeting. But I understand there's some extenuating circumstances, and there's a good possibility that's why the letter's not here. I understand that.
We've had some discussion about the QBS standards as it applies. We've had many discussions about the QBS. I didn't realize the board had requested an attorney general opinion, and if I did, I forgot, or I would have been
Oh, it's
prepared
fine. It's fine.
to discuss. But we've had several. I mean, that is a difficult question to answer as far as that particular statute about QBS standards, because it does not. And I've read the statute, it does not make a definition of construction services and including land surveyors or within that. And so I will certainly check on the status of any letters. I don't think any had went over. Ms. Avers may. Yeah, she is not aware of them, and we will have a discussion with, I'm going to talk to my supervisor, the deputy general counsel, as well as the assistant commissioner, and about, because if you ask me for a strict interpretation, I would have to say land surveyors are not included in that statute because they're not specifically listed. And had the legislature intended for land surveyors to be in there, they would have put land surveyors in there. However, there's another argument that says construction services has to include land surveyors. So, you know, you can argue on both sides of the fence, I guess, which, you know, but if you ask me today, is land surveyors in there or is included in there, reading just the plain language of the statute, I'd say no. If they meant to be in there, it would have been in there. So I will check on that, and I will have a response to you at the next meeting, if that's
Well,
acceptable.
obviously, you can understand if it's going to be that we're not included, then maybe somehow or another, some surveyor somewhere needs to maybe speak to a legislator
Right.
and see if that can happen.
Right. I agree.
Okay, so, I mean, that's, you know, it just gives sense of direction, is where I'm looking at on that. Couple other things. In the past, in our legal reports, one area of concern, and I think I can speak for the board, has been with our when a case reviewer reviews a case. And matter of fact, the one that we just approved for further review by a case reviewer is a good example. Obviously, we at the board cannot know a lot of things about the case, but we have to know, you know, certain things about the case. And where I'm going with this is the previous reports that we have gotten on a lot of complaints have been very, I'm gonna use two terms, brief and somewhat limited. Now, obviously, you can't write a novel because you divulge too much of the case. I understand that. But at the same token, I think that it could be a little more, let's say, explanatory, so that when the board makes a decision, they can feel like that they're more confident in that they have made the correct decision, so that we don't see things coming back. And I think that if you look at our track record with our complaints, I think that we're probably one of the top ones in the department as far as how we handle them, how they move through, how they're resolved, and so forth, even though they may not be as egregious as some of the ones in other boards and this type of thing. But I think we do our job there, but it would be good, you know, and we have even asked in the past to actually talk to the case reviewers, but I think we've been denied on that from a standpoint that, you know, I think it's important that the board is able to kind of give a roadmap over time for a case reviewer, so that the case reviewer, you know, if, for example, if it's cases about A and they never look at B and C, but there was a violation in B and C, we would never know that. But again, I'm certainly, it's not a witch hunt either. You know, as Jay said so aptly, you know, we want to give that respondent every opportunity, every, you know, option that there is before we have to do whatever we have to do if they did do something wrong. So, you know, that's always kind of been a concern of mine, is that we, and I get that from the fact when I came on this board, these members on this board reviewed these cases. We didn't have a case reviewer. You know, you reviewed a case in a different general grand division of the state that you were not in and reported to the board, and of course you excused yourself from any voting or anything else. And the reason for the case reviewer obviously is because we're not a very big board, you know.
Yes, sir.
So-
I understand, and that has always been a balance. And I've been with the department for 5 years, so I've had conversations, though not directly with you before, but with several of the boards, and heard that concern. And it's always a balance to strike between maintaining the anonymity of the case and giving enough information for the board to make a reasonable, well, it doesn't apply here because it's a criminal standard, but I always tell attorneys to, you know, provide enough information that the board can say there's probable cause as to whether or not there was a violation, and we can go forward. And so sometimes some attorneys, and, you know, will provide enough information to do that, and sometimes it's difficult to strike that balance. But I am confident in working with Ms. Martin for past year and a half that she's detail oriented enough and communicative enough that she's going to be able to do that, and we will certainly take a interest and look at making sure we're providing the information necessary to prevent matters from ending up being represented at a later date. So, but I do understand your concerns, and certainly we'll work with Ms. Martin to try to address those.
And I have to agree with Mr. Lingerfeld. I think a lot of times when we see a single paragraph, there's just not enough information to make me feel comfortable, even though we.
Sure.
Information is worth its.
We will be very cognizant and work on that, and Ms. Martin and I will certainly, that'll be a focus going forward, that we're providing enough information without providing too much information to quash a respondent from getting the due process they deserve. So
We don't want to put you into any undue efforts or situations or because of lack of something to have to go on to the next level of, formals and all that kind of stuff. Because, that takes your time, costs the department money and so forth. And we certainly, we just want to try to do, as Mr. Northcutt said, the best job we can and go home and put our head back on the pillow that next night,
I understand.
And we appreciate it. Like I say, I'm just sort of bringing up to speed a little bit because I know we've had a change and
Sure.
that's fine.
And I appreciate that. I really do.
I'm certainly not trying to educate you because you know more about all this stuff than I do by a long
Well,
shot. But these are just a few things that I've been concerned about.
Okay.
And I think that they're nothing major, but they're little tweaks that I think will make things flow much more seamlessly in my mind. I'll just stop right there. I had two other things, but I'm gonna stop right there.
Okay, well, if you want to email me or have any concern, I have my card and I'll give you the information, and we will, Ms. Martin and I definitely will focus on those areas. And
I know you do a great job. We've always had great, I think, communication and cooperation, and the legal department has always done a great job.
Thank you. We appreciate that, and we want it to continue.
That's good. Anything else? That concludes the legal report. Maybe I need to get up here where it's, I can say we conclude the legal report.
Thank you, Mr. Chairman.
Yes, sir. Thank you for being here this morning.
Absolutely.
Okay, I think the next thing on here, why don't we just go ahead and take the director's report and,
Mr. McCormick come in on if he wants to talk or not.
do a.
He does, and if that's okay, I will include that as part of my director's report.
Have part of your director.
Right.
Okay, that's good.
correct.
We'll do that.
The Assistant Commissioner is here today, Brian McCormick, and we have been discussing the way we process applications in the department, and part of our discussion has been around the examination process and reciprocity. So I'm going to let Mr. McCormick talk about this, and I will, of course, talk about this also, but I think he wanted to communicate. So I'm just going to let him introduce himself and talk to the commission also. I want to put him.
Morning, and I also have a problem.
been waiting.
I have to get close to the
Yeah.
microphone here too, so I always struggle with speaking too loudly. But I just wanted to say, I know you, Mr. Lingfeld, you were asking legal, and I'll just tell you, I'm very, very excited for y'all to get. I don't think I realized that Laura was going to be working as your counsel. She's fantastic. I've worked with her in a number of different areas, and so you are going to be. Mark is a great supervisor, and I think you're going to be thrilled with the quality of legal representation you're going to get. So, just to speak from my standpoint, I'm pretty excited for you all that you're getting her. So I didn't know that until this morning. So that's awesome. The next thing I wanted to talk about was I think we were, so some of the things we've been looking at since, I think we talked a little bit this last time I was here. We talked about the implementation of the new licensing system and how we're kind of working from an administrator. And as you know, my primary role for all of the programs, we have 30 or so programs here that do licensing for all kinds of different areas. I think, programs like yours, we have cosmetology, CPAs, engineers, funeral directors. We're actually now licensing the athletic commission. And so we've got a pretty wide range of licensing. But I think primarily what I think we're really good at is focusing on how to get the administration of your programs done efficiently. And that's what I'm committed to, is making sure that the process that you experience for you all as a board and the experience for the licensee is an efficient process. And so we've been looking at, we're going through a comprehensive review of all of our programs in terms of licensing process. And so one of the things that we've been noticing over the last couple months is and we look, and the way that we report to the governor in terms of CFG numbers, it's one of the things that we're requested is related to licensing time. And so there's a number of things that we both control and we don't control. But the way I would talk, one of the ways I look at licensing is how long does an individual spend interfacing with one of our boards or commissions. So that's from the first day they submit an application, whether or not that's for licensure or for testing, for instance. We start the clock because oftentimes you apply for testing and then, well, once you pass the test, then you're licensed. Well, one of the things that we've identified is that one of the prominent reasons that we have programs that have licensees spend a significant amount of time with a program relates to a requirement for the board to approve testing. And so we have been reviewing that in a couple of areas. We've adjusted this and cosmetology was one of the areas that used to require a credentialing process by the commission on the front end. And so I wanted to come to you all to propose what we've been doing in other areas is to look at, essentially, as someone comes in here, we see ourselves as licensing, and so what we found is we're much more efficient. The average length of time, I'll tell you, for instance, last month, the accountancy program, their average length of time for a licensee to interface with the State Board of Accountancy, as you know, they take the CPA exam. They've got pretty rigorous requirements, is 4 days. And that's all the applications. And so one of the reasons that happens is they have worked with their testing vendor to do things such as educational verification. So the precursors to testing, the boards have delegated that authority to the testing company. So the individual is actually not coming to the licensing program until every requirement has met. Now, they still have to meet an educational requirement. They still have to take the test. All those requirements are still necessary. But essentially, one of the things we've noticed is that programs that do require the qualifications to be checked on the front end, particularly something like education, we see that our staff will spend a significant amount of time on processing whether or not someone meets the requirements to test, and then a person will, one, never take the test. They might take the test and fail. And so we're spending a lot of your licensee resources and your all's time by working on something that's not a completed application. And so we are encouraging, and I'm doing this, you're not the only program I'm speaking this to about. There's a few that are still left that do it this way. But we're encouraging you all to employ the relationship with NCWS. I make sure I get the acronyms right, NCWS, as they do provide this as a service. And most testing vendors for all of our licensees are moving in this direction, where the licensee, the testing vendor will determine, in terms of eligibility for testing, they do all the credentialing on the front end to make sure a candidate is eligible to take the test. I mean, and so we're hopeful that you all would take a look at this as a consideration, because I think from an efficiency standpoint, what you'll determine is, and most of these are really, and what I'm focusing on are the technical requirements of saying you're now eligible to take the test. I'm not talking about, there may be some other requirements that, such as on the back end when you receive their testing, let's say you want to look at plats, and that's an example. I know something that you all do take a look at. You could do that on the back end with the completed scores, but if you do that and they pass the test, the length of time that like I said, a licensee would would spend with the board. And, you know, I think one of the things I don't like about it is that we're spending time for folks that aren't necessarily even ever going to be licensees of your industry because they don't pass the test, they don't complete the test. And we want to say that if you allow for that to be taken on by another entity, I think you'll see incredible efficiencies, and I think you'll see a happier licensee pool in terms of the process. So that's my general kind of pitch to kind of get you all to think about the subject. I'd love to answer any questions or kind of tell you why and this is sort of a holistic approach from the department standpoint that we think this is a good practice, but I'd be glad to answer any of your specific questions or broad questions.
If I may, Mr. McCormick, I am a member of the examinations for professional surveyors with NCSS. I also am on the exam writing committees for the PS examination. Have a little bit of knowledge about this for whatever it's worth. NCSS does do a program that you're speaking about, and a lot of jurisdictions across the United States utilize that program. However, most of the jurisdictions that I'm aware of do not have what I call the combination of credential requirement that we have. Our requirement basically speaks to some type of education and some type of experience to get to that point of examination. Now, I will tell you that there are states that allow NCSS to approve a candidate. In other words, if you're from state, for example, I'm trying to think one that does it right off the top of my head. I believe Louisiana does it. They will allow a candidate to apply directly to NCSS to take the first examination, which is the FS examination. The candidate can then take the examination, and should they pass the exam, at that point in time, they actually apply to their jurisdictional board for actual to be able to be certified as a PSLIT. But that's based on that board's review. In other words, they come to the board with the examination already passed, and then they make application. And until they meet the board's requirement, they don't get their PSLIT.
Actually, that's essentially what
Right.
that's that process you just laid out is exactly what I was suggesting you all consider.
Just so you know, you're talking about timing with applicants, and I'm going to pick one area in our statute, okay, and rules. And it says, in order to qualify to take the FS examination, if you obtain a high school education, diploma or general equivalency diploma, GED, with a record satisfactory to the board of 10 years of progressive practical experience, 6 years of which have been under the direct supervision of a practicing land surveyor. So what I'm saying to you is, yes, John Doe or Jane Q. Public can take that FS exam when they get their diploma or GED, and then it's 10 years later before we ever see them again. Whereas today, if John Q. Public and Jane Q. Public apply to us, they already have that, and we're ready to move them forward in the process. So, you know, my take on that is I understand where you're coming from, but that would seem to turn your numbers that you're looking at from the time that a person would apply. For example, I go pass that test, I send in an application, and the board denies it and says, well, you've got to have 10 years experience. 10 years from now, I got to come back and apply to the board to get my PSLIT. And then once I get that, I have additional educational or experience requirements to be able to sit for my PS examination, which is also in this statute that I could read, but I won't bore you with that. So what I see is time saving in that environment becomes a terrible number for you all to have in the department that says that John Q. and Jane Q. Public have been in the system now for about 15 years. You know, I don't see that as helping your numbers.
And I wouldn't describe it just from a number perspective. I think what I'm saying is from an efficiency standpoint. But I will tell you, CPAs, as I was just mentioning, they also have an experience requirement as well. So this isn't I guess the conversation of like kind of when they'll interface. I'm essentially saying that we don't see it being an effective use of boards and commissions' time to require them to do verification of certain things that testing companies are already doing. We're saying the testing company can do this for you, and they do it. And honestly, I'll tell you that there are industries where this is becoming more and more desired across where industries that haven't done it are realizing from a testing vendor standpoint, it's something they need to start adding to their repertoire because it's something that's becoming a trend.
To be very candid with you, I would agree with you 100% if all jurisdictions, or just even our jurisdiction, if we want to limit it to that, was strictly a BS requirement, such as in engineering, for example. They have a BS requirement for engineering, from an engineering school. If we were strictly the way that we were before our law had to change in 2014, I would have agreed with you 100%, and I would have been on your wagon with you, and we'd been moving forward with that 100%. But because we have all these other components with it, I see it somewhat problematic as for efficiency.
And all I can speak from is my other, and I tell you, we have, I don't think the challenge that you're discussing is unique to the qualifications or are unique to you all. And I can tell you that in the other areas that we're doing this, it has been very effective. And as we talk about how long a licensee, the areas where we generally have the longest time for our licensees to be through the process here is at programs where that they don't do, where the program does the initial vetting instead of allowing the testing vendor. It's typically the longest process.
Don't you also think that if we did go that way, that we'd also have to have a legislative change of the way that that this current statute for licensing is written?
The onus would seem to be on the licensee to meet the qualification, and if NCWS is willing to pre-qualify, allow them to take the test, then when they apply to us for a PLSIT application, applicant would have to qualify in order to get the license. So if they didn't meet the qualifications, the application would be denied. So they wouldn't be eligible for the license if they didn't meet the credential. Have the 10 years, that would be a non-starter. So it would just be denied. I mean, if they applied and they didn't have it, just as any other applicant, if they didn't meet the requirements for the credential, it would be a non-starter. It just would go no further. And I did submit a mock application for you, just a starter, assuming the instructions, register with NCWS, pass the national exam, and then submit to us, just to show you what it would potentially look like if this model worked. And this is actually following very closely what they do in California, because this is exactly what they do in that state. They go through this exact process in that state for all of theirs. It is done in several states, but they actually follow this exact model in that state.
In terms of the conversation, I would obviously want to vet this whole process through legal and making sure that we can do all of these things. It is my understanding that we could, but I don't want to. I wanted to bring the idea to you all to kind of get your temperature, so that if it's something that you're amenable to, we can start working toward the process of showing you how we would implement that.
Well, I guess it's half a dozen one, half a dozen another. I don't necessarily disagree with you. I'm just looking at the logistics of how our licensing law is structured. For example, I'm going to expand on where I was going. At a high school diploma, you got to have 10 years. Then you get the board approval, you go take your test, okay? You pass your test, then after June of 2017, you have to have 6 additional years after you have that PSLIT. Then you take another test. And then after you pass that test, you take another test. I mean, that's the roadmap. I mean, that's set out right here by statute. That's the roadmap. Now, obviously, it's shorter than that if you have a BS degree in surveying. But my concern is, you know, that's a long window of time. I mean, any way you approach it, but if you approach it when you get that experience, your window is actually shorter to the end result than it is if you start here and, you know, I mean, you're still doing the same window of time.
But what we're saying is, I think this, to me, this is, I'm trying to describe this as kind of an administrative thing, not a policy thing, because kind of how I see it is, what we try to do with all our professions is make it very clear that when you come to our board, to our website, call our staff, talk to someone, that we will tell you these are the requirements that are needed for licensure. To meet licensure, you have to do these things. And so in an area where, I'll use the CPAs again as an example, they have an education requirement, they have an experience requirement, and they say to their licensee very clearly, you have to apply with the accountancy board with the test passed, with all the educational experience requirements completed. And so when they come to the board with, we are now prepared to be licensed, they say, here it is. And at that point in time, we look at it, we do and typically those questions they look at it, they check, they validate, and once that's validated, they either approve or deny. And so I guess what I'm getting at is that I think that I want to put the expectation that a licensee knows when they come to our program, or a prospective licensee, we'll be giving them all the information on the front end to make it clear this is what's required, but don't come to us for requesting licensing unless you've met these requirements that are laid out for an individual. And that way it spares them time of having to go back and forth with the program about, well, now I have to do, it's clear these are the things that are needed, and that's when you come to the board, when you have done all those things, and at that point, the decision on licensure will be made.
Question, I don't know anything about how an accountant gets licensed. Inferring from the way you're describing it, that they only take one examination. I know it's multiple parts, but it's all just one exam. So see, we're looking at 3 exams.
Well, and they're actually, and I'm using accountancy because I know that they have some comparable, but there are other areas that have apprenticeship requirements that they have. They may have to take one test to be an apprentice, then be an apprentice, one test to go from an apprentice to full status. I mean, we've kind of, I will tell you, we've kind of got the game. I mean, I think you all may have some pieces that are arranged in a little bit of a unique flavor. You probably do, but in terms of, there's really nothing that we've seen that doesn't kind of, the variations are there are variations of it, but some programs have multiple tests, some don't, some have one test, some have requirements, some don't have any educational requirements. I mean, it's, you kind of got the game in terms of that.
The most obvious question for me then would be, how will that benefit this board, the staff, and the prospective licensee?
I think it'll benefit everybody, because less time will be spent on applications that are not completed. Less time of your time, less time of an applicant. An applicant knows they only come to the board when they've completed the required pieces. So they're not gonna have a back and forth in terms of, if I know that I can just go take the test, for instance, if I know that and I have the educational requirements, I can just go directly to the testing vendor to test. I can test and then come to you once I've completed the test. So that's one less step for an individual who's a prospective licensee. And from a staff perspective, they're not going to be working on applications that may or may not ever get completed. They're only working on applications that are completed, which will make it faster for the people who are applying that have met the requirements, which we want, and that's what we want to do. Ultimately, we want to get the people to work as quickly as possible. And by having folks that are completed in their applications, we see it just happens faster. That's practically what occurs. And then the in terms of your time, I think you would not be having to spend time reviewing applications until they have done all the things necessary to be licensed. So at that point, you are really focusing on the cases that are that have some question about whether or not they should be approved or not.
I would ask Ms. Nicole then, how many of these applications are you having that people don't follow through and take the test, and that basically you've wasted your time on, and we've wasted our time on? That would be my question.
Well, you would essentially remove the necessity to review the PLSIT entirely, and the upgrade ones would be the ones you would have to focus on. I mean, the PLSIT would be administratively reviewed, and the land surveyor applications, you would be reviewing the plats. And
Okay, well, let me ask you this question. You said we would not review a PSLIT application only for the initial testing, but they would not be able to receive their PSLIT until they had an application before this board that met the criteria for PSLIT. So you're talking about the same exact application. All you're saying is that if John or Jane Q. Public want to go take the test, they can go take the test, and then they'll apply to us whenever they want to, if they want to. And if they pass the test and they got it and they never use it, that's fine too.
That's
I mean, that's all you're saying.
That's practically, I mean, it kind of really boiling it down. That's practically what I'm saying. I think that piece can be managed by the vendor.
I don't see any difference in what the current function that we're providing relative to that individual, other than the fact that they already have the PSLIT. Well, they have passed the exam. They don't have the certification, because only this board can certify them. So all you're doing is just saying, okay, any John and Jane Q. Public that's out there that wants to apply to NCAAS to take the FS land surveying exam in the state of Tennessee, go do it.
And I'm saying that they can vet what they're doing as a back, kind of the backstop that you're providing now by reviewing those is they can still potentially do the backstopping as they do in other states. I'm saying it's a process piece that I think is.
I don't think you'll find NCAAS is reviewing the application in the same manner as a jurisdictional board is. I think all they're doing is basically taking the basic information, the fee, and scheduling the individual to take the test.
Lay out parameters. I mean, I can just tell you I've worked with a lot of testing vendors, not NCAAS on this. I've worked with the largest is PSI. I've worked with NASBA, who does accountancy. I mean, I think this is a trend, and vendors know to do this process as they're getting more requests to do it, that they have to provide more services, and I think that's an expectation that we could put on them in the contracting process as we do other places.
We will be meeting, Southern Zone meeting on Thursday and Friday and Saturday of this week, and I'll certainly make a concentrated effort to talk to David McDowell, who is over that testing, and also Tim Miller. Discuss this with them and find out for sure, make sure that what I said was 100% correct about how they look at it, what they look at it, and at what level of detail that they would be willing to look at it if a jurisdictional board asked them.
And I think one of the reasons I knew NCAAS was going to be here in town, and so I'm glad for you to do that. I think that would be valuable. I mean, I'm having the same, I anticipate the conversation. This conversation is going to be happening in other areas that I think the engineers are here, and I think they're going to be looking at this. I anticipate asking them the same type of questions in relation to this as we would do.
I think they already do.
As NCAAS does. So. And we're that's, I would love for you all to explore, and really that was my purpose today, was to kind of get the conversation sort of started for you all, because and we can I want to look into as much data or anything that'll help you kind of make that decision, but I wanted you to know from a division, that's the way we're going. I mean, that's the trend in the division. We're asking every program to do that, and so wanted to kind of get your thoughts and see if it's something that you're amenable to. So.
Well,
thing I want to make a note of here, if I understand the process correctly that's being proposed here, I think actually it benefits the prospective registrant.
Right.
In a sense here, and hear me out here. We talked about the 10 years of experience, right? Let's say the applicant takes that after 5 years of experience, takes the exam, right, and fails. Takes it again after 7 years of experience, right, and passes, right? After they complete that full window of 10 years of experience, then they make application here. They've passed the exam, assuming they have all the credentials and everything. They're validated as an LSIT. They're in. They're good with the 10 years of experience. They're in. The way the process works now is they have to complete that full 10 years of experience right now. Make application, take the exam. Let's say they fail it the first time. Then life goes by, 1 or 2 years goes by. Now we're up to 12, we're up to 14 years. They take it again and pass. It took that applicant 14 years to get to that point of passing, as opposed to where the alternative could be that application or that applicant could have taken that exam once, twice, 3 times within that 10-year window and then gain licensure at the 10-year window. At the end of that, I think that's a benefit to the applicant there. Also, administratively, I think it helps out a lot too. I think there's a lot of applicants that come through here that for whatever reason don't pass, or life changes and they can't become a surveyor for whatever reason. However, that paperwork has generated its way through here. They've paid application fees that didn't go to the successful passing the exam. It's come across our desk for review, et cetera, et cetera. That process, in a sense, for the most part, gets eliminated because we know that we've got an applicant that the major stumbling block being the passing of that test. And if they're able to take it within that experience window, they don't have licensure until we approve it, right? I mean, they may have passed the test, but you still have to get the
They
licensure.
don't get certification.
But I think it has some legs there. I think it has some interest there. I'd certainly like to pursue it a little further and see where we can go with that. Because I'm all in favor of getting the registrant. If they can accomplish these tasks in the most efficient path possible, we need to encourage that. Number one, to cut their expenses. Why keep applying if they don't, can't pass the exam? And number two, let's limit the amount of time. 10 years is a lot of time. But if you find someone who's assertive and aggressive and serious enough to take those 10 years, let's do what we can to get those 10 years through, get them to apply and take that test, and then let's get them through.
Well, I'll put my 2 cents worth in for what 2 cents is worth. The 10-year thing, obviously, we tried very desperately to have the path to licensure through education and a BS degree, but we had a couple of constituents over in Knox County that decided that they wanted to follow the 10-year path, and through the legislative process, we came up with the amendment to the law which says, okay, BS degree is fine and that you're going to do that, but until 2017, you're going to have to put up with the 10-year, as they call it, the 10-year rule, which there never was such, but that's what it was termed. But then after 2017, you're still going to have a 10-year and a 6-year and what have you, which is an apprentice-type program. And so we're saddled with everything and really wish that we had just the education requirement, because that would go a heck of a lot smoother to get through that. And can I say?
I think what I would just commit to you is that whatever requirements you have, we're going to try to make it administrate as efficiently as possible for you. That's my commitment. I mean, in terms of that, the legislature has opined on that, on kind of the process, and I'm going to defer to them on that. But I'd say we'll make this work efficiently for you all, whatever your requirements are. And I think what I was trying, by giving you sort of examples of earlier about kind of the ones that we've done, I would say that it's worked in the various different professions with different types of requirements, and that's why I was trying to say I think we have credibility. I would say that if you talk to some of our other stakeholders who've done this, and that they would say positive things about the credibility of us in implementing these type of programs.
I'm very much in favor. I have to agree with Mr. Kaufman that whatever we can do to benefit the registrant to get through this process, the better he'll like it, the better we'll like it. Because we see this thing over and over, and here comes an application. Because of whatever reasons he's not able to pass the exam or what have you, and then we see it again. There we are. It just drags out and out and out. So there's a couple of things. The registrant's got to be committed to do what he needs to do and apply himself. And the other thing is the time constraints that we have here. Let's get done and get through with those. I'm with you, so.
Okay with you, just based on what I've heard, we'll kind of continue to, and I think Mr. Lingerfeld will have some feedback from NCAAS the next time we get it. We'll continue to work to try to see what we can do to put this in place for you all, and then kind of share that with you at the next meeting, and we can kind of discuss it more then, if that's appropriate. Obviously, I defer to you if you want to take more immediate action. That's just my suggestion.
Well, the only thing I hope is that the next time I sit before the legislature and they say, well, you're not abiding by the law, and I said, well, but yes, I am abiding by the law. They won't say that to me when we put this in place, will they?
I most certainly will be there with legal to defend anything that we do as an administration.
Okay, that's good. So, anyway, look forward to tweaking whatever we need to tweak. And I'm sorry, go ahead.
I asked Nicole a couple of questions about this application. I think it's on the table for discussion, isn't it, Nicole?
Yes, it's a rough draft. It's
I
not,
understand.
it's not final work or anything.
It seems to me that you're asking the applicant to pay the $25 non-refundable application fee twice.
It's after, that's just the instructions. It's this would be after they've taken the test, and that's with this application.
Step 3, recite whatever statute that they have to meet. Because when they actually, let's assume for discussion purposes that NCAAS, we agreed and let NCAAS let them take the exam, and now they're submitting this professional land surveyor and training application to actually get their certification, as it says. Then, based on what was just said, it should say something in there about, per, rule or statute, whatever, that's what you're applying for, so that it comes in the form that it should be.
For references the statute that's applicable to.
On the back of it, on the back of that page, it asks the question, says, are you licensed or certified as a PSLIT in another state?
That's
You
just in
only get it
case.
once.
I know, but we have to ask the kill questions on these applications just to make sure that we don't have. It happens, so I'm making sure. If you think it's a silly question to ask, I'll eliminate it, but that's why I'm putting these rough drafts together.
Well, if they already have a PSLIT in Florida, they're coming to us to ask us to be, if they're here, to be examined as in the PS, not as the PSLIT. I don't grab the merit of that, but that's, that's just a couple of things that I saw right off the bat.
I just want to make sure that they're not licensed already, but if you think that's a silly question.
They can only have a certification as a PSLIT in one state in the entire United States. That's all they can have. They can't have it anywhere else. That means that they passed the NCAAS FS examination.
All right. We'll eliminate that question. One type of.
Yeah, no, I understand that, but within the past 5 years, have you been convicted?
I'm not real sure on the NCAAS record if you can have a record until you're. I want to say no, but I don't know the correct answer.
I'm sorry, I didn't catch that one.
I'm not sure that you can have an NCAAS record unless you are a licensee. as in a professional.
Well, they would have to have an NCAWS number to have taken the test.
But that doesn't mean they have a record. The record is what we get from them to keep from reviewing all the application data. That's a function that they provide. In other words, Mr. Green's kind of got that question in his eyes there. What NCAAS does, for example, if I'm licensed in the state of Tennessee, then I can submit my information to them and they will craft a record for my information. And then if I decide I want to become licensed in Kentucky, all I have to do is ask them to provide my NCAAS record as a licensee to the state of Kentucky or any other jurisdiction that I might want to apply for. And I pay a fee in order for them to maintain that. And what that does for me is it tells the next jurisdiction that I'm applying for, all of my schooling, everything that was basically had to be filled out on that form. That's an NCAAS record.
That applies for PLSIT? Okay,
Not to my knowledge. I'm gonna say not to my knowledge.
okay.
That question came specifically from a PLSIT application from another state. So that's the record number for,
You get a number, anytime that you register with NCAAS, you get a number, and that's your number. Because so they can track you, how long you take exams and where.
I would assume that anybody who interfaces with them, they've got a record of.
Yeah, oh, yeah.
Right, so-
Yeah.
that specifically is asking, this application is assuming that they have taken and passed the FS exam. This is the inverse of what we do now. This is assuming that. This is, again, this is just a rough draft,
Yeah.
assuming that the inverse.
Well, I figured it was
So,
open for discussion.
it was
so all
just
I
a further
doing was
discussion point.
That's
Right.
all I was doing was discussing.
So, this was just a discussion point document.
I think it'd be great if you all want to take what Nicole's giving you to review it, and I think we'll kind of I want to continue to present sort of what we think is the final best product to you, and so I'm glad to continue the conversation on this. I think we really what the purpose of this for us was to get just take your temperature on it in terms of seeing, and
The MBA for California, Rick Moore, is on the same committee that I'm on, and I'll be seeing him here in a few weeks at a meeting anyway, if he doesn't attend here. And I'll certainly ask him about his process that they do, because, I mean, he's the one who handles it. He's the Nicole of California.
yeah, I'm so excited that you all are. I thought this was honestly, from my perspective, I thought this honestly had nothing to do with NCAAS being here. Just happened to be at a time we got up to it, and I was thrilled that NCAAS would be here so you could inquire. I assumed you all would want to. I think it's great that and that it happens to be right down the street. So. That's really all I had on that subject. Did you? I know we were. I think.
Also want to talk about the reciprocity issue.
Yeah, I'm gonna let you.
Let me tackle that one, all right? That's fine. The other topic I wanted to briefly touch on is establishing a kind of a template for how we address the reciprocal applicants that come in. I want to put out kind of a good policy for how we treat our reciprocity applicants, and by comedy, I think we should maybe create an application for them in a streamlined, efficient way for them to gain a credential. The way they apply currently, they basically have to do the same thing that any applicant does, as if they were a resident here. The laws and rules don't really address that a candidate has to do that. I've researched it pretty thoroughly in your law, and there actually isn't anything that says a reciprocity applicant has to complete the exam. It doesn't say that they have to do anything except submit the application and prove that they hold a licensure in another state. I'd like you to consider possibly revising your policy on that. I certainly understand making them complete the examination for the Tennessee examination, but I'm not really sure why we make them complete plats to gain a credential.
Brings up a good point. You used a term that we're not allowed to use, and while Mr. Green's here, I'm going to address it because it was on my list. The word you used was policy. We have been told that this board can't have policies, but I know there's other boards in this department that have policies.
I never said you can't have policies, but the policies can't affect the licensees. The policies affect administration.
Well, it's my understanding that the purpose of a policy is to, I'm going to use the word embellish the definition of what's trying to be explained, per se. I mean, that may not even be Mr. Green, my East Tennessee English may not work with your Middle Tennessee etiquette, and I apologize.
Maybe clarify.
Let me, a policy, like Ms. Aver said, a policy is meant to clarify a administrative procedure. A policy is and your statement that other boards have policies, that is something that we are and have been addressing as far as policies that technically should be rules. Policies that make a statement to a requirement of a licensee is bad practice and should be codified in a rule if it's not already. So when you have a policy that says if you have a rule or a statute that says this is the requirement, a board cannot then enact an additional requirement by policy. Now, they may have the authority under the statute to enact a rule regarding it, but if it's not, then that would be the only way that you would be able to make an additional requirement. Now, the one that we're talking about is under reciprocity. And I don't have that statute in front of me, so sorry, but
It's on the iPads.
I was looking for.
62-18-110.
Applicant may, in the absence of disqualifying evidence, be deemed by the board to be fully qualified to practice land surveying if such applicant holds a like unexpired certificate of registration issued to the applicant after examination by proper authority in the District of Columbia or in any state or territory in the United States in which the examination and requirements for registration of land surveyor are of a standard satisfactory to the board. That's the statute on reciprocity, and they're,
Examination and requirements for the registration of land surveyors are of a standard satisfactory to the board. So currently, if a licensee from another state applies and they're licensed, the board procedure is to have them,
Two things. One, we determine how they got their license, as far as what their requirements was, to see if their requirement meets the requirement that we have at the time that they got licensed.
okay,
Okay? We feel like that's fair. Secondly, we test all of them, because in our world, different than the engineering world, the exams that they take in their jurisdiction are jurisdictional exams, just as our exam is a jurisdictional exam, which means they're looking at their statutes in Indiana, and we're worried about our statutes in Tennessee. Now, in the engineering world, that don't work, because in the engineering world, you get a PE wherever you're at, and it's part of your canon of ethics that it's up to you to understand whatever the jurisdictional requirements are for wherever you work. But in the surveying world, it works a little bit different. It shouldn't. It shouldn't, and I wished it worked like the engineering world, but it doesn't.
so you check the standards in which they were licensed at the state, and then you make all applicants retest, and that's state-specific information?
To our examination.
And that's common with every state. Every state has its own specific, usually it's a typical 2-hour exam. For instance, I'm licensed in 7 states. I obtained my original license in California, but I've taken 6 additional state-specific exams to obtain those states. Make sure that they are qualified for your state-specific minimum standards in
And each of those additional states have their own exam, so.
Yes, and they verify my background, my educational background, my experience background. So this is, the way we do it is no different than any other state, quite honestly. There might be some administrative differences, but the basis of it is the same as any other.
did each of those states verify your plats?
That was the state specific as to their requirement. Our requirement is that we'll verify that they draft plats that are to the Tennessee standards. Some other states do, some don't. But each application to that state specific and take a state specific exam. Plats is state specific. You know, Tennessee, yes, we review on the plats that they meet the minimum standards for platting. It's very important.
Examples, I'm licensed in 5 states, same scenario, Jay. When I applied for licensure in Georgia, they had a date that if you were licensed in another jurisdiction prior to that date, then you got your license by comity. I applied, and for that very reason, the board reviewed my application, didn't even realize that was in the statute, and said, well, we still ask everybody to come take the exam, so I had to go take the exam. You get a whole mixed bag of tricks. I looked about applying, give an example, another example, I looked about applying for a South Carolina license. Well, because the state of Tennessee was not giving NCAAS examinations until in the 90s, I was licensed in 77. I did not take the NCAAS exams. Now here's a real anomaly. I've actually written questions for both of the exams and signed paperwork with NCAAS that I can't reveal, you know, what I write and so forth. And seeing the exams, I've actually taken them through cut scores and so forth. South Carolina said, we'd be glad for you to come and get a license in our state, but you will take the FS and the PS along with our state-specific exam because you have never taken them. Just to give you an idea of, you know, what other states would require in order to meet their criteria.
Yeah, I don't really understand what the issue here is with reciprocity, other than maybe it's just not specifically spelled out in the language. But as far as I'm concerned, the procedure that we go through for someone that's out of state, already licensed and coming into Tennessee, is really no different than any other state out there.
Well, I would like to agree with Nicole that I think it would be good if we could have a reciprocity application, that we might be able to, let's use the word condense somewhat, so that it wasn't, the reciprocity application was not the same exact application as a person applying for the TS exam in-state. I mean, I have no issue with that at all. I mean, I'm 100% agreement on that. I think that would be good, and that would help her and her staff help move that one on through. It may even help us function as we review it too.
Yeah, if there's anything we can do to make the administrative aspects of it more functional, more efficient, I'm all about that. But I want to make sure that we're still covering the basics of what each applicant has to.
I think and I want to clarify from a legal, the board has the authority to establish the requirements that they deem as appropriate. I want to make sure that it's covered appropriately if it's ever challenged, and that's the crux of the matter.
And I think what you and Ms. Martin will find that we still have, and I believe the statute is that, didn't look at what's in the bottom corner, but a great majority of that book that you're looking in right now, even though it's not 100% current, was written in 1969. And that's what the process, that's none of the process we've been ongoing about trying to get some of these things updated. We've kind of hit the heavy hitters, but there's little things like this and some other areas that we still need to do some work on to try to get it to where it flows better, it's better supported legally, so forth and so on.
I could chime in for just a second. One of the things I was wanting to, and I think I've completely lost my train of thought here.
I'm glad somebody is senior like me.
Same neck of the woods, so most of my East Tennessee. No, I was going to say that I think one of the things that we are doing, I wanted to comment on the policy versus rule piece. We are taking a concerted effort across the board to have interpretation of statutes laid out in rules. I mean, we think that policies, the way that Mark explained it a minute ago, was exactly what I would say. I mean, I think we're trying to do that department wide, and we're looking at the entire range of the policies, because we are concerned that they aren't necessarily defensible and they haven't gone through the vetting process that the rule making process is intended to have. So I think this is a good conversation, and particularly related to this subject and any others. And that's really that's the purpose behind it, is to make sure that we are following the correct process to give folks the proper both expectation and opportunity to opine on the interpretations of statute that you all choose to employ.
Further discussion?
There's
there's a couple of things. One probably is it's break time. Trust me.
May I wrap up the
And
director's
so
report?
if we need to kill the camera, fine. If we don't, but it's 10:29 and I know one, so, and we will come back.
Before we have a break, I was just wanting to see. I'm planning on leaving, but I wanted to be. If you had any other questions, I'd be glad to come back. I just wanted to. These were the purposes of why I was here. Did you all have anything else you needed to ask me, or would you like me to come back?
Appreciate your comments.
Great.
Love to
Please
see
do.
you.
And I'm trying to make a little bit more of a concerted effort to attend meetings. So I'll at least maybe try to. If on occasion, if there's something that we need to cover, y'all want to ask, I want to be available for those questions. So thank y'all.
Thank you. Thanks for coming to be with us.
Anytime. Thanks, y'all.
Good. Break time. Real quick. How quickly can we do that?
A minute?
A minute. I like a minute. And it's now 10:40 and
Thank you. The budget report is posted on your iPads on page 6. The last 4 years' financial information is included, including the year-to-date budget information. The total expenditures as of December was $86,491.30. The total revenue, $320,475.28. Legislative updates for the month. House Bill 1613, Senate Bill 1505, which is the sunset for the Land Surveyor Board as introduced. That bill passed and became Public Chapter 539, which extended the Land Surveyor Board 5 years to June 30th, 2021. House Bill 2496, 2594 is pending governor action. That replaces specific language allowing denials of licensees for felony under different circumstances. As of March 24th, 2016, a sponsor was added to that bill in the House, and in the Senate, it was transmitted for governor action. That concludes the director. Oh, wait, I'm sorry, there's a couple more pages. I apologize. House Bill 1914. That's a statute of limitations and repose. As introduced, that one permits a person who owns real property and who has not paid taxes on a real portion of property for more than 20 years to bring any action to recover the property if failure to pay taxes was due to an error of land surveyor.
Nicole, if I can interject on that one real quick. That one that you're speaking of, that was actually a typographical error by the sponsor of the bill. The word land surveyor actually should have been the word appraiser, a land appraiser. And actually that bill is dead in the House for the year, so it's going nowhere.
Thank you for that update.
Yes, ma'am.
And the website's been updated with all the board's requests from the previous meeting. We welcome any additional input from the board members as to content for the website. You certainly don't have to wait for a board meeting to update our offices about any ideas you have for the website, so just email me or Cody if you have anything you want updated. We already covered the application information. I will work on a reciprocity one and present it to you for the next meeting. Newsletter update, I gave you a copy of the draft of the newsletter. So if you have any comments about that, if not, we're going to submit it to our legal counsel and the communications director for approval, and then we'll send that out to our licensees. And as to the exam process, we've already discussed that. So that concludes the director's report.
Will you still be able, Nicole, will you still be able to accept continuing education from any registrant at any time?
Definitely.
Okay.
And that's actually on the second page. Okay, on page 2, you'll find a frequently asked questions about that new continuing education reporting requirement. That should address the 3 main ways that people tend to submit their continuing education.
And we do get continuing education turned in at all times. We get them almost every day.
Well, it's back to me. Mr. Lingerfeld, I'm sure, is looking up something here concerning that.
I just wonder if we shouldn't identify that as PDH as opposed to CEU. Because if you get into the statute, the CEU is a situation thing. Now, that's just a question. I'm just throwing
No,
that out.
I agree.
All right, we're going to ask one of our guests here today, Mr. Lanier. You had speak to the board, and so here we are. You can speak to us, tell us who you are, where you're from, and it might be best just have a seat there where you can speak to the microphone, and that way you can tell us what your reason.
Yes, sir. My name is Lance Lanier. I'm an engineer intern with Ledford Engineering and Planning in Arlington, Tennessee. I'm a professional land surveyor in training, Simpson Land Surveying in Middleton, Tennessee. At the current time, the main part of my experience, I worked for Jeremy Loudenbeck in Arlington, Tennessee. Loudenbeck Surveying. After I got out of school from out in 2012, and worked for him solo robotic for up till he sold out to a company out of Florida called ARC Surveying and Mapping, and they do mostly laser hydrographic work, and I did not follow that path and do the traveling, so I went back to where I started my surveying when I was 17. I could do, and the guy that worked with him, I first started out, and he actually has helped me to keep going on with my to work as a PLSIT, and he's helping me out, and I was able to submit my plats with him as the person in responsible charge, and I have about 11 years of experience in land surveying, and I can be approved to take the PS and the TS. I passed the FS February of 2015, and I feel ready for my PLS licensure, and told by a telephone conversation that it was denied on the experience. Questions about the experience that y'all have, and if anything I can to help you understand how much experience I have.
I was looking here.
Tap it, it'll pop the menu back up, you go live.
Tap the center of your iPad. And then you will see the word library appear in the top left-hand corner.
Don't give me time to do it.
I've got one ready. I'll swap you out.
I'm not very. What was the date that you indicated that you took and passed the FS examination?
2015, the first part, I think I would have gotten notification before April of 2015. I probably passed it in February, I think is when I took the actual test.
It says right here, it says February 28, 2015. I was one of the members that reviewed your application, and in my notes here, from February 2016. It says references indicate applicant is not sufficiently prepared by his experience and education. So let me go to that reference. Jeremy Loudenbach, if I pronounced that correctly. Loudenbeck, okay, thank you, sir. States that Lance was not office staff and has had little or no experience in that position. Goes on further to state, it says, the standard question on here says, based on your opinion of the current knowledge, skills, and capability of the applicant, do you recommend him or her for licensure at this time? And the surveyor has checked no. So if Mr. Loudenbeck is your employer, he didn't seem to rate you very well on his reference sheet. Okay, then there's a second thing from Mr. Loudenbeck that says, would you trust the applicant with responsibility for an important land surveying project involving the welfare and safety of the public, which is a huge concern to this board because that's what our charge is, protecting the public welfare. And his answer is no. I would need to make all calculations, but that's just me. Next question says, would you recommend the licensure of applicant when experience and examination requirements have been satisfactorily completed? I would, only when experience and exam is passed. I don't believe now is that time. And as much as I hate to tell you, Mr. Lanier, that's why that I denied your application.
In addition, also from the same RLS that you worked under there, he gave reference to, although he gave reference to 49 months of experience being reported, he said that based on when he calculated by full-time, part-time hours, that really it only added up to a total of 32 months.
32, yeah.
As opposed to
I'll
49
pull my
months.
tax records on that.
Again, that's based on his records. They're
Yes,
not anything else. I will say to your credit, one of the other references that provided favorable recommendations on your behalf. So that's certainly to your credit there.
The time that I submitted this application was right when he sold out to ARC Surveying, and I understand why y'all denied it though.
Well, you know, Mr. Lanier, this is the first time I've had the honor of meeting you, and I want to tell you that great respect for you to come before this board and present your case and position, all your interest and work and endeavor in our profession, and I hope that you will continue. I'm also the one to tell you that I'm sorry that I had to read that information to you to explain to you why that you were denied. But you know, you have that first step in 15 for your SLIT, and based on the current statutes with you know, a couple more years of experience, already working in that process because we're already into 16, so you're moving along well. So I would certainly encourage you to go back to where you're working and work hard do a good job, continue to learn and improve and advance, and we look forward to seeing your application at the appropriate time back.
Sir, I appreciate y'all hearing me.
Okay, and let me go back here. I would like to go ahead at this time and ask Mr. Cleveland if he would give us the professional organizations report, TAP's report.
Thank you, Mr. Chairman. I submitted a written report this morning. Apologize for not getting it to you any earlier. Basically, I'll just kind of touch on the highlights. A couple of weeks ago, we had our spring conference, and approximately 330 seminar attendees were registered for the seminars, and had approximately 35 participants in the land surveyor review workshop. That was almost double what we had last year. So interest in that program seems to be growing. Still looking at trying to revamp some of that material for the ever-changing exams. I'll be spending a lot of my free time in the next year or so to try to get some of that information updated in that. We included in this report a couple things that have been ongoing discussions that just restated what has been previously reported in previous reports. One thing I would like to mention that's starting to become a growing concern both at the NSPS level. Our NSPS director Bart Craddy brought it to our attention at the meeting is which several of us were already aware is there seems to be a national, some states are trying to push for the deregulation of certain professions, and that's something that we are definitely concerned about. So we don't want land surveying to become deregulated in the future. So,
Cleveland, any comments? Anything we need to ask Mr. Cleveland? Taking the time to come and give us a report.
thank you for the opportunity to let us be a part of the meeting.
Okay, now then, Ms. Nicole, I punched a gizmo here, and I've got things that I don't want.
Well, if I might redirect you back to the education report on the agenda.
Okay.
That's what we skipped from the director's report section. If you tap your iPads and then go back and hit education report. So tap the center of your iPad, hit library, and then tap the first one, which would be the one that says April agenda. Touch the word that says education report. Straight to it. That is a summary of the education that's been approved since, by the Education Committee since we last met. So if you would just take a quick review of it. These include the Kentucky Association of Professional Surveyors, Arkansas Society of Professional Surveyors. They had several courses. Approved in April, just a few days ago. Any questions for me about that?
Yeah, the only one that pops out to mind is one that was from the Arkansas Society of Professional Surveyors. There's a 1.5 PDH awarded to, in quotation, session with the state surveyor. I know that Arkansas does have a designated state surveyor, and it's specific to Arkansas and the surveying that's done in Arkansas. I don't see how that is of any benefit to the surveying in Tennessee. All the others I'm fine with.
Well, I had a question on the vendor showcase.
Vendor showcase, yeah, I just saw that one too, yeah. Those two, I'm not sure, I don't know, I'm a little uncomfortable. The vendor showcase, I really I really don't think we can be given PDHs on that one.
Is there some way, Nicole, that we could get a response from the advisory committee as to why they gave credit for those or whatever?
Okay, I could do that. Vendor showcase.
Vendor showcase in the session
So
with the state surveyor.
let me get that thing.
This is both the same course, right? Or provider?
Two separate courses, but
Yeah.
both were provided by the Arkansas Society of Professional Surveyors.
We have a question, Nicole, relative to the advisory committee. Their charge says that we appoint them and they are to assist us. Technically, shouldn't we have a motion to approve what they do? Because they're only an assistance. The actual approval of the continuing education should be the board's, if I understand it correctly. And I'm not sure that we've been doing that, so I'm just curious. This would be a good opportunity to make sure that we sort of, let's use one of them legal words, codify what's going on.
I guess my understanding is that the education committee was reviewing and approving it, and if the education then the board was voting on the hours,
Well,
determining it.
0820-05-.15 Advisory Committee states, the board may appoint an advisory committee to assist the board in evaluating continuing education programs to determine the allowable credit to be awarded.
Correct.
But prior to that, in here, it says that the board is responsible to determine the merit of the
Right.
program.
And that you'd appointed a committee to assist you to do that.
I think it's something like what we're seeing here. I
Yeah.
think this is the system working right here.
Well,
Is
my question
advisory
is,
is
my
reviewed it
question is, should
and
we have a
recommend.
motion as these are brought to us by our director to just simply
Yeah.
approve them?
Yeah, I think at some point this board has to review, like we're doing here.
Right.
Question, if any, like we've done here.
Right, right.
And then formally, by motion, second, and approval of the ones that we approve of.
That was,
Yeah.
that's where I was going.
Yeah, I think that's.
You're all over it.
Yep.
Who is the committee? Is that,
There's, three, is that right? Three individuals?
3 individuals.
I think one in the west, middle, and east portions of
not
Tennessee.
board members?
No, they're licensees.
They're licensees.
They're licensees.
Okay.
Yeah, and they're appointed by the board to review all the applications of the educational content that comes in. They give an opinion of approval or question, and then ultimately ends up here.
Okay, all right,
It's a great system.
okay.
It works well.
Mr. Cleveland.
Yes, I noticed you mentioned the Arkansas, the ESPS approvals. Is that something that after this meeting or maybe at lunch, is there something that they've been notified about? Because their conference actually starts tomorrow, and I'm attending that conference. So I've had a lot of, believe it or not, I've had a lot of questions asked me the last week or two if those courses have been approved. I don't think a lot of those people understand that TAPS and the Board of Examiners are two separate entities. So that may be a question that comes up tomorrow if some of those classes have been pre-approved for Tennessee.
Well, I think what you can respond to them at this point is that based on if there's a motion, they have been approved. However, there appears to be two here that we're going to kind of put into question and limbo for right now for
I knew-
Tennessee approval.
I knew there were several because I think there was one on GLO notes or something in the program that I had told them, I knew that y'all would have to review it, so.
If that's the case, then I'd like to put it in form of motion that we approve the courses as submitted by Kentucky. All the courses submitted by Kentucky. I'd like to approve the ones by Arkansas as well, except for the session with the state surveyor and the vendor showcase. I'd like to see some more written material on the explanation of how those benefit Tennessee.
Second that motion.
Okay, any further discussion? All in favor?
Aye.
All right. Motion carries. Anything else that we need dealing with education?
No, sir.
Not nothing, huh? Okay.
Just need to do the
Nicole, are we still on schedule to invite Mr. Messier to the July meeting?
Yes, sir.
Okay.
Most important thing we do.
Okay. Time to review applications. So bring it on.
You want to take a look on your iPad, it's the same process, going back out and then selecting by last name that we just did for Mr. Lanier. And then I've got the hard copies.
Yep.
Just a question of curiosity. Since we typically review applications by hard copy, and only thing that is seen or heard on the video is just our verbal discussion, does the screen that shows them computer-wise, does it show up on the video?
No.
Okay. Okay. I didn't want to divulge any information that we shouldn't be divulging from that standpoint.
Here's our first candidate, it's a PLS.
Decent, yeah.
Difference.
Benson.
On your iPad, you'll be listening.
Oh, wait.
Beeson, I'm sorry, not Benson.
There it is.
I guess we gotta look at it on TV soon.
High school with it.
If I may, this is a PLSIT candidate who is applying with high school and experience. However, he submitted a college transcript, but it indicates his date of high school graduation clearly on the top of it. So,
Until 2017, we will continue to receive these. They may have a bachelor's degree and what have you, but unless it's in land surveying, then we're going to get these these.
RLSs he's got on there.
Well, frankly, what I'm saying is that he's got 10 years in a high school.
It's good to go.
Or that we fill this sheet out. All right.
Next applicant is Christopher Michael Cook. He is applying as a PLS through Comedy.
Denials before they got to come in front of us?
Well,
It should be two, but it's three.
It's three?
the issue at the February meeting was his plats, meeting our standards, and also he is relying on his NCWS record, which we had not received the day of the meeting, I guess because of how long it takes them to submit it.
I haven't looked through all this, but did we get the information from NCWS?
We did. That's why it's there's such a lot to go through.
Plats that came here, did he resubmit the plat with the,
And the plats are not on the iPad. He submitted them. They're in the back of the file. Yeah, those should be the revised plats that he submitted since the last meeting.
You guys like the technology curve that Cody's thrown you here?
Noticed.
Liking this?
Challenging.
Big improvement. If you'd like it, I also have a magnifying glass. Asked for one. There's one in the bucket.
oh, is that right?
Yeah. You asked for one, I brought it.
Oh, good. Trust me, there are times when we do need one.
The older I get, the more I need it.
I also have my reading glasses, which are just a low magnification, but a little enough that I can read.
The transcript from the last day.
I looked at that too.
Please. There's something, but anyway.
Blow it up.
Big.
Yeah. I couldn't read it over there, that's why I come over here so I could read it.
How's that?
That's good. Scroll down. Keep on going. Okay, stop right there.
What do you not see?
Vicinity map?
It's the very same thing.
No, it's not. It's not required though.
No, it isn't required.
It's not required. So he has to give a general description of where the property is. I'm looking for that.
For a vicinity map, and I said, well, it's not, where,
Yeah, he's right on with that.
he is.
He got that one down.
Exactly right. Now you just take a look at disclaimer on there that said these were done to the standards of. It's that on here, but now then, he doesn't have a location map or to get to the property. I'm not saying, that's not required, but we usually ask for.
Well, I think he does. He does because he has quarter section corners right here.
That's what you look for. If we don't have something, look for something else that we can give the guy.
I'll learn more about land surveying than I ever thought I would, I think.
I'm sorry, it's good.
I might ask for a career change eventually or something.
I don't know, you probably make more money doing what you're doing.
I don't know about
You can
that.
get all sorts of poison ivy and all that stuff. It's great.
Look what happens to, look what happens to us.
Is that what happens?
That's what happens.
Tell you that I
What's the
did,
map look like?
I did take one
One
of
of my
the
other programs, which I accidentally wrote down one of the
previous
Athletic commission.
board's attorneys with me
Boxing match
on a
coming up.
surveying job.
Did you?
I did.
is boxing?
Chris Craven,
Uh-huh.
Told you I have all kinds.
Chris went with me and I got him
boxing and Mixed
sunburned.
martial arts.
I
That's big
mean,
business now.
the next 3 but I did take him out. He wanted to go, he wanted to see what was going on, and so he went with me, and we went on one that he had asked me to go on, and I burned him up.
I saw Chris a couple weeks ago. He's in private practice now. Yeah, yeah. It's
I appreciate that guy. He was really good with this kind of stuff.
Chris really got into the technical land surveying and contractors especially. Yeah.
Very technically oriented when it came to. Okay. I guess I need that. Think that's all right, do you? Did you look at it, Sue? You want to see? All right, then, Ed. Okay, there's that one. Great.
Looks like on this one, we'll be looking at he's applying under a BSN 24. We probably want to check his 24 there.
Our next candidate is Mr. Dillard for PLSIT. He was up for review at the board's last meeting. We had not received his transcripts at that point, and his course reporting form appeared to be incomplete. He was also missing his third reference. We received the transcript, we received the third reference, and when presented with the opportunity to complete his course reporting form, he did not. He declined. So take a look and see for yourself. All he has. I
Tim, give me again the hours that he has on one and two. Doesn't have any? Wonder he didn't fill out the course reporting form.
I wonder, on our website, Nicole, is that breakdown on there?
It is, and I shared it with him.
Or he doesn't have the form filled out. It's a deal killer, he doesn't have the classes.
That's the issue.
That's the issue. That's the issue. So he should have. He should have a minimum of 18 hours from list number 1 and the remainder from list number 2 and number 3, which is 6. Probably could take care of that, but he doesn't have hours from list 1 and 2.
Can he qualify under a different way?
He said he could not. He
No,
didn't have the
because he only
experience.
has 12 months surveying, well, he's got 12 months surveying experience is all he submitted. Is that correct, Cody?
Yes.
And that was, this is quite interesting. This one was 8 years ago that he had 1 year in surveying. I don't know where this gentleman's going. And he's not even working for a surveyor currently.
So,
This seems like the
Would
kind of
you like
guy
to-
that would, this seems like the kind of guy that would send his application in to NCAAS and go try to take a test.
would you like to put that in the form of a motion to deny the application?
Yes, so moved. It's not there.
I'll be glad to second Mr. Kaufman's motion.
Okay, motion made and seconded. Any other discussion? All in favor of denying? Aye. Okay. That's a question though,
He didn't have the coursework and he didn't have the years of experience.
if,
You need a reason.
if we,
Apparently, he's a police officer. That's what he's been doing for the last 7 years.
that's a strike against
Strike
us.
against him right there.
There you go, Jay.
He said jokingly.
Yes, very joking.
Nicole, I have a question. If we deny, do we really need a motion? Or if two of us are gonna sign off on this sheet here, that's has been our practice in the past, do we really need a motion, for these unless there's verbally on the record?
It doesn't hurt to have a motion and a second to deny an application. I have it officially then.
And that's okay. I don't mind, but we haven't done it, but you wanna start that, we can start it.
Usually when the board is taking, so if in your statute it says that this is a board action, the board approves or denies, for it to be a board action and not an individual action, there does have to be a motion.
So the written thing is just a confirmation that we probably took a.
Correct.
I think you're the one reviewing it.
Our application statute says if two or more board members recommend examination of an applicant, such examination will be required. That's all it says.
So it doesn't have to be a board decision, it's just two people?
Two of the board members.
So what would happen if two of you agreed that he should be denied and two of you wanted him and two approve?
Have to discuss it a little further.
Okay.
Well, I'm just, that's all I got to go by.
No, I
And
didn't
if it's
know
wrong, we need to
exactly
fix
what
it.
it said,
Yeah.
but generally, I'm sure the reason Nicole took that path is because for there to be a board action, best practice is the whole board has to have a chance to vote on it.
Well, if the whole board's going to vote on it, then all four of us need to review it. And then. But our rule only requires two. But in other words, let me say this question. Why should Jay and Galen review the application and Sue and I sit down here and look out the window and watch the weather go by, and then we be asked to vote to approve that application? We hadn't even seen it. We would like
No,
to look at it.
I don't disagree with,
Yeah.
I'm trying to think of the process.
Yeah.
What Nicole and Laura are talking about is if it is a board action, I mean, here, as I'm viewing this process, I'm looking at it as the board reviewing the applications, the board as an entity. And if the board's going to take action, then I totally agree that a motion, whether to deny is appropriate. However, if what's really going on is two people and you're just switching up or taking it, then
That's the way we did do it. We're
Yeah.
doing things different today. Yeah.
okay.
In your honor, we're doing things very different today.
But the thing, of course, what we did is that all the applications were laid out, and he'd take one, and I'd take one, and all four of us had a different application. And then when we handed it to the next person, whoever was available to take the second look at it, and it only took two to look at it and decide, it does or does not meet our requirement.
Okay.
We'll vote on anything you want us to. I have no issue.
You are discussing and deliberating as a body now, though. I mean, it is in front of all of you, and you were discussing it and took action as a whole. So, and you were discussing denying it. So, in that instance, since you said his experience and his education did not meet the requirements, you were taking an action as a whole. I mean, there wasn't anyone that wasn't aware of what the application standing was.
Well, as this one being denied, then the other ones, we should add a motion on them to approve as well, to be consistent. Or we can have one motion to approve all the ones we already approved, whichever.
That's how I would do it. That's how I would do it.
And that would be the most efficient.
That's the most expedient way to do
Yeah.
that.
Yeah, just do the ones that we deny individually, and then at the end, we have a motion to approve all the ones we approved. Is that okay?
I am comfortable with that, yes.
I'm fine.
Is that okay?
Well, Jay was a while ago. Oh, that's right, this is the bad one, wasn't it? Next.
This is candidate Timothy Durr from Kentucky. He has been, this is probably since the Donna days that this application has been with us. We finally now have it completed. There are two issues that you probably want to look at. Number one, his school, his high school, was not able to provide him with a copy of his diploma or transcripts. They did provide him with grades. I'm not sure the difference between that and transcripts, but
I would have no issue with that because he's licensed in other states. In other words, he would have already, particularly he's licensed in Ohio in '95.
Yeah.
So I thought he would have fought that battle then.
well, the other issue is that we still have not received his NCWS verification as of this morning. I spoke with Mr. Durr's secretary of their office last night to double check on it, but it has not arrived. I printed out what I could find, which was only proof
Well,
of his state-specific
correct me
in
if I'm
Connecticut.
wrong. Correct me if I'm wrong, Cody, but this gentleman is applying to take our TS examination.
Correct.
So he actually has until our July meeting to have everything in order.
That's correct as well.
And if he doesn't have everything in order, I personally feel like we shouldn't review his application until he does. And I mean, because we're not delaying the applicant at all
That's
from
Yeah.
approval.
Yeah.
Because his deadline is actually July the 15th to be able to take the next available TS examination.
Yeah.
So, I mean, I would make a motion that I guess we would table any action on Mr. Durr's application until such time his application is complete, and he would not be delayed or whatever until July the 15th. He has up to that time to get everything in. And once he gets it in, we'll be glad to review it. That's my motion.
Motion made.
If this is up for some discussion, if his plats are here,
You have to have a second.
That's why I said the
Or
motion
no-
is
no
made.
second before you.
Well, I'll second it then, for discussion.
Do what?
I'll second it.
All right. The discussion now, then, Cole.
if his plats are here, and since he's a reciprocity applicant, perhaps just in the event that there may be issues with his plats, just because we've had issue with reciprocity applicants before, if you could take a look at his plats, just to make sure there might not be any issues, so that if there is an issue with his plats, we can communicate them to him so that he doesn't get here in July and then there's a problem and then he doesn't make the TS exam. I would feel really bad telling him in July, you've been sitting here in our office for all these months, and then now you can't take the test for another 6 months. So if you could please take a look at his plats rather than tabling it and then not looking at it just because NCWS hasn't posted his academic record or whatever the deal is, rather than tabling. I'm happy to make that your motion table contingent or whatever on that last final piece. When we can wait till July, that's okay with me.
That's good.
Okay, so we want to table it though until we get the last piece of information. The plans look good and everything else is in order.
Yes, that's fine.
Okay, motion's made and seconded. Any further discussion?
Aye.
Opposed? Okay. Holland. Derek,
It's a similar case where
Derek,
Howard on mine. I don't have a
there's a
Howard.
Howard and a Holland. Holland is technically.
There it is, way above everything. There it is. There is one. Snuck.
So his issue was, again, making sure that the plats met our standards. He submitted last week revised plats. They should be on the iPad, and then there are also copies in the file.
Had he submitted once before?
Yeah, he's been up for review twice, I believe.
So strictly on the plats?
Yeah. Previously, there was a missing reference, but we received that.
Come on, I was like Memphis.
what's wrong with this
Wait a
picture?
minute.
There's a Memphis and a Nashville, Indiana.
Arkansas.
Nicole, we need to communicate to, several of these I've seen so far, they want to complete the forms twice. They want forms that are attached to the reference employer is the same form as the other one. So we're asking them, they're understanding that they need to fill out the same form twice.
That's in the instructions for the PLS application, that if you application form, then you are a reference and you must fill out a reference form.
Well, they don't get it, though. iPad's really slow when you blow up a PDF in it. It does a good job, but it just takes it a while. Oh, okay. Oh, we got seconds, is that what you're saying? That's all right, that's okay. I've been a lot lower on the food chain, so it's all right.
You're competing against real estate today.
First of 16, but he used all to 2011 standards.
Oh.
10. I count 10 here.
Yeah. Quarter to 12, and I think that,
Well, a couple of these don't count. We've got linears in here.
can we do two of them pretty quickly, you think?
Yeah.
Yeah, give us the two that will go the quickest, and then we'll head out.
Oh, didn't have his date across the stamp there.
That's correct. According to the last meeting, he did not meet the standard.
Certification didn't meet it either today. Yeah. Says in his certificate, the basis of bearing was a previous survey performed 11/09/09 by Abbott Engineering. In order to know a basis, you'd have to go back to the previous survey to do that, I would think.
Could one of you summarize what the issues with the plat is on the board member sheet so that we can communicate this to him, what his issues are? I'd appreciate that.
I felt that
Yes.
coming my way. That's fine.
You felt that ball coming your
Yeah,
way?
it was coming. I'm ready to catch it. Come on.
Let me put a,
Are we in favor of denial here?
yes.
I make a motion that we deny this application based on that's being incomplete, of which Mr. Kaufman will detail what those are, and if the applicant will resubmit to those revisions, that it will be re-reviewed at our next.
All right, made and seconded. Any other discussion? All in favor?
Aye.
All right.
Got one that I think we can hit pretty quickly. This is Christopher Kinner applying from Kentucky under bachelor's in 24 hours. And his application is complete, but the issue that I see is that I don't think he has 3 professional surveyors among his reference forms. They are mostly engineers.
Yours are. Okay.
Take a look for yourself.
All right. It has to do with references. Everything else is pretty complete then.
Yeah.
Okay.
The application is complete, including reference forms. It's just
Poor at best,
Yeah, inadequate to locate property.
yeah.
You said something about the
Certification isn't right either.
It doesn't have Tennessee certification.
So he made it, he just made it.
Where are we on here? Kenner?
He did not come before the board.
1214.
Yeah, he just makes it.
He does.
Yep. I figured that. All over that. I got all over that.
Well done, well done.
Surveyors, he's got one engineer that had a whole bunch of things that he stamped and checked and what have you, but
For a motion, Mr. Chair, I'll make it.
all right, I'm ready for a motion.
Okay. I make a motion that we deny this application subject to proper references. And I'll hold my motion to the plat. So, Mr. McCullough.
He does have site map.
Yeah, but we don't.
Gotcha.
Has an interesting certificate. This one's a combination GPS and conventional survey.
Is his staff
That don't have a stamp.
Well, this one has a stamp, but no signature.
He's got a signature, but, he's got a signature, his signature
Not on
stamp.
the
You
stamp.
don't have to sign your stamp in Kentucky.
This is not the stamp.
Yeah. Oh, okay, there it is,
Standard, so
okay.
you
Look
do.
here, it's under my thumb. No wonder I couldn't see it.
Still gotta sign it in Tennessee, though.
Yeah, I know you do in Tennessee.
All right, I'll second that motion.
All right, motion's been made and seconded that the application be denied until applicant provide professional references
And the plats
And-
need some modifications.
and that motion made and seconded, all in favor? Opposed? Okay.
Sue says time to eat.
Is it hard to sit that long?
Well, I hope it rains to
12 o'clock must be the witching hour, or the lunching hour, the time to break for lunch. Okay, time is about 2 minutes after 1, and we will reconvene the quarterly board meeting of the Board of Examiners for Land Surveyors, and our next item on the agenda is engineers. Welcome to the land of surveying. And we're here, at your disposal, whatever you would like to discuss. Any of us up here, my brother Tim Lingerfelt has some things I'm sure that he needs to discuss, whatever that is. And let's see, John is not here yet, but on his way. He has the orders of the day and for the next couple of days, I'm sure, lined out for us. So anybody have anything that you'd like to just open up and say? Because you're welcome to say.
Could we do introductions?
Yes, we certainly can. Would you like to start with this end here, and then we'll come to you, or would you rather?
Direct, since you're sitting where you sit.
Well, I'll tell you, we'll start up here. I'll start over on my right-hand side with this young lady, and Sue, tell them who you are, where you're from, and what
I'm
you do.
Sue Brawley. I'm the public member, and I'm from Pulaski, Tennessee.
Tim Lingerfelt, registered surveyor from East Tennessee, Representative Kingsport.
Galen Northcutt, Middle Tennessee Representative, Registered Land Surveyor on board.
Hey, good afternoon. My name is Jake Hoffman. I represent West Tennessee, and I'm from Memphis.
I'm Nicole Avers, I'm the executive director, and I'm here from Nashville.
I'm Laura Martin. I'm attorney for the board, and also I'm from Nashville.
I'm Mark Green. I obviously can't figure out the microphone very well. I'm Chief Counsel for Regulatory Boards Division, also from Nashville.
Okay, now it's your turn, Hal. Work with that bunch here too?
Yes, sir.
Oh, well, okay, all right.
I'm Zachary Nitschke. I'm the paralegal for the Earth. I'm Steve King. I'm the associate.
Lipscomb. Well, get that program running over there. We need, yeah, okay. I heard that it is. I just never went there. We're glad to have all of you here. And look forward to getting together with you guys. I wish we could do it more frequently, and maybe we should, but we haven't done so. But now with the meeting coming up tomorrow, the NCAAS, I'm sure that there are things that we need to cover, and I'm not sure at what path I need to go next to cover those things. But I know that some of you will be working this evening, Mr. Lingerfeld and I, and Hal, and we'll be trying to figure out how to keep from getting wet going to the restaurant and what have you. You don't have an umbrella, and we're not going. Okay. Oh, should have known. But anyway, we're going to be doing that. But anything that you guys want to talk about? Because it's open. The floor is open for discussion. For anything that you want to discuss. And I'm quiet. We're not going to say nothing. Afraid we get in trouble.
When John gets here, he may have some more detail. But if there's any.
I would encourage anyone who feels like that, please feel free to take that whole front row of chairs and come up and speak into the microphones, because it makes it recording then, and it also makes it so much easier for everyone to hear.
I was going to say, please do that. Thanks for saying that, Nicole, because you guys are very softly spoken. We're probably the more outspoken ones here, so and we talk loudly, but please come up and have a seat. If and when you speak, just if the little red light does this particular thing, you know that you're being heard, hopefully by everybody else, and that I think the camera is running and it just sees the back of your head. So
Our identities are protected.
Absolutely.
Is there any state legislation that you all would be interested in discussing?
Well, we do too, and here's our state legislation guru right here on my left, and Jay watches very cautiously everything that goes through, and I know that the Tennessee Association has their lobbyists that they go in and look for these things, and hopefully they catch things before they get too far gone, and we have some things to work with. But Jay, anything on some of the things we were discussing even this morning?
Yeah, well, first I want to give credit to the Engineering Society of Tennessee, because they do a great job of tracking. Their website is great. I get their emails, and there's stuff on there. I'm like, oh, I didn't know about that. Look at there. So whoever is keeping that up to date,
Casey,
all the credit.
We'll have her speak when you're done.
All the credit to her
And she can
for keeping up to date with that. I did. There was one item on there that I was a little curious about. It had to do with, and help me out, hopefully I give you enough information to get on the right track. It was about receiving payment on state contracts. Was it on a monthly basis or some kind of basis?
This is my folder on that.
Wow.
Casey, would you come up to the lectern?
Sure.
And I guess it just kind of tuned into, well, how come surveyors can't be included in that, or are they included in that?
That's not the goal of the legislation,
Okay.
is part of that. So we've been having a lot of trouble with our state contracts. We've been renegotiating the contract for about 18 months now, and really just, so the bigger of the issues in that bill, the second section is, addresses additional services versus basic services. And y'all, surveying comes up several times in that list of 64. So we've gotten through, the goal of that really was to force the hand to say, you've got to pay for what you're requesting, particularly when we're having to go to, pull in outside people and things. And so what has come of it is we've got, we really have switched the of legislation and have been working with Stream out of Department of General Services, TBR and UT. Those three, it's really, it just addresses the three state procurement agencies that go through the Building Commission. We've got a phone call this afternoon where I hope we are going to seal a deal. And that has been the goal all along. There's a new contract that we've been working on that doesn't, the monthly payments is tough for them, just because of the percentage of work complete is problematic. It also has contributed significantly to the $31.7 million fiscal note we got on that bill, that we've gotten down to 18.2, which I consider a win, but we're still not going to pass a bill with an $18.2 million fiscal note. But I think that there's some language in the new contract that we're looking at now that specifies more frequent percentage payment more frequently in the different stages of design. So it should really help. We've also nailed down descriptors on there are some things that are maybe not always going to be additional services. Sometimes they might be, but we've been specific and clear about when they need to be additional, when they need to be in base. Hopefully that's all going to work itself out. But we've been through, we finally cleared both committees we thought were important last week, and then we were double referred. So we cleared yesterday. They reopened the Business and Utilities Committee for us yesterday. And they're all aware of what's going on. And actually, John Hull, who's the Assistant Commissioner, Deputy Commissioner of Department of General Services, spoke on our behalf yesterday. So we think that one's going to be good. But perhaps not as legislation.
The only other thing maybe.
Oh, there was a big, y'all pay professional privilege tax, yes?
We don't.
Oh, that's because they start with S. And when that was developed, they went through the list.
It stays
Well,
in
never
this
mind.
room, by the way. Stays in the room.
I
Go outside this room.
Look what can of worms you
No.
opened up.
Come on now.
No, they won't be adding
Maybe we
anything
need
to
to
that.
amend it to surveyors.
No.
There were a couple of things that have
Are
come up.
they not phasing that out?
So-
I thought they were. I thought I read that.
There's a bill in there that will not pass anytime
Oh.
soon. There was a bill this year that would have excluded out-of-state residents from having to pay professional privilege tax. And from the engineering side, professional engineers alone, that was like $2.4 million a year. So there is a bill that is a good bill that will force this. But there were a couple of things this year that I think all of us were concerned about at the beginning. There was one that was part of some federal procurement that we've taken all professional services out of. There was a bill that had some the fire inspectors would not they would not have to do field inspections from the state fire marshal. They could do field inspections in lieu of plan inspections from the state fire marshal's office. Verbally, we were okay with what they were trying to do, but they couldn't write the specifics to exclude us from the bill, and so instead we had the bill is viable. I don't know if you have any other questions about any. I'm happy to answer.
All right, then let's do that. And, John, the floor is yours and the rest of the afternoon if you need it.
I wouldn't say I'm prepared to give remarks, but at any rate, I've been at the Lowe's Hotel all this morning, getting ready for our registration. All of our delegates arriving. Got all of our goodie bags together. I want to give a special thank you to the chair of the Surveyors Board and also to Laura Reinbold for providing us with some items to include in our goodie bags. We have, I think you'll be pleasantly surprised at all of our giveaways that we have. So NCAAS provided a nice budget for that. But you've all received information about the meeting, kind of an overview of the agenda. Begins tonight with our dine-around event, and we've got 4 escorts participating in that. Everybody's, I think, received that information.
Unpaid escorts.
Well, 2 are unpaid, 2 are paid, yes. that is registered for the event. So, yeah, if you have specific questions about that, I'll be happy to answer those or attempt to answer those. Of course, the actual business meeting doesn't start until 1:30 tomorrow. That's when the actual meeting begins. But there is as I mentioned, registration this afternoon, tomorrow morning. We have the first-time attendee lunch tomorrow afternoon. And then Friday, we have meetings most of the day, of course. Friday afternoon, there is a door prize to tour the Parthenon free of charge. Mr. Lingerfelt has agreed to escort that group, correct? All right, that's still correct. Very good. Appreciate him doing that. And that's going to be led by either Candy Toller or her husband, if Candy can't make it. She's traveling, so she's not sure if she'll be back in time for that. But we're actually, originally we were going to start it at 3:30, but we're moving it to a little bit later to 3:45 because depending on who wins the door prize, there could be some guests participating who are doing the lunch cruise on the General Jackson that day, so they may not get back quite in time for us to make it there by 3:30. So it'll start at 3:45 and end around 4:30ish, more than likely. So, and then of course Saturday is breakfast, and we may have a meeting Saturday, we may not. It depends on how quickly they get done with the business. The chair of the vice president, I should say, of the Southern Zones informed me that she thinks we may get done with everything Friday. If we do, then we'll just have breakfast Saturday, and then everybody's free to go home or tour Nashville, whatever they want to do. So if you have any questions, I'll be happy to answer them. I think we're in a good shape. We better be at this
point. Do we have a
point.
rain plan for tonight?
Well, it's a welcome reception. I'm sorry for the dine-around. I'm thinking Thursday, right. The dine-around, I mean, we've got a budget of, we averaged about $85 per person. That was the registration fee for that event. I don't think that we'll probably need quite that much for most of those that attend. So I would say we'll have some in the budget that we could use for transportation. If you would think you might need to get a taxi rather than walk to the restaurant, or Uber, Lyft, Laura says, whichever you prefer. If you want to use some transportation service like that, I think there would be enough money for reimbursement for that. But yeah, you're right though, with the rain, depending on how hard it's raining and the wind, et cetera, you may need transportation rather than walking. But they're all certainly within walking distance if the weather's nice.
What about parking? Will we be able to park over at the Lowe's? Because I'm not staying at the Lowe's, so I'll be driving over there.
Yeah, they have a parking garage. Of course, there's a fee for that.
Sure.
And I would assume with your travel request, that parking was included in that. Nicole's nodding yes, so you'll get reimbursed for your parking after the meeting. Yeah, just like those that are staying in the hotel will. I think like $30 a day. Or take Lyft, Laura said.
Take Lyft, I'm telling you. Park free somewhere, then take Lyft over.
Close to downtown, it should be $5.
It's like $4. It's nothing.
Hal prefers Uber.
I'll use Lyft.
I'll give you the app. It really is. They have a corporate headquarters here, that's why we keep saying that.
But as soon as you're done with your meeting, come on over. We'll get you registered and get your goodie bag. And unless you want to provide that, for staff, so we have more goo-goos and stuff to eat. And we can kind of go over the dine-around that for those that are escorting it. If you want to get there a little early before 5:45, kind of go over the plans in a little more detail if you'd like.
That would help us, I think. So, would help me. And Tim, you guys already know what's and where and what have you, but.
Stay at home, I ain't from around here.
We have to have an interpreter sometime to understand Tim's Eastern Tennessee English.
As far as motions, Hal's asking about motions that might be presented at the meeting. that may come to a vote, other than the elections, the officer elections, which I'm assuming y'all aren't talking about that. I think Alabama is presenting a motion to charge a committee with amending the model law regarding council records to require that all references be provided by registered professional engineers, or it may apply to surveyors as well. I'm not sure if it's just engineers or if it includes surveyors. I think that's going to be presented possibly as a motion for the zone to discuss and vote on. But
there's the agenda.
okay. But most of the states that I've heard from are opposed to that because most states don't require all references to be provided by professional engineers. I don't have the actual motion in front of me. It may be worded to say that all experience must be verified by professional engineers. I'm not sure exactly how it's worded, but you get the gist of it. So as far as I know, that's the only motion that'll be presented at the meeting, unless some are made actually at the meeting. Yeah.
Okay. Anybody have any questions that they would like to ask? And Tim had one other thing he was going to bring up, but that didn't have anything to do with NCWS. Just has to do with interprofessional.
Yeah.
So, John, thanks for the update on this, and I'm sure if you have something that is earth-shaking, you'll shake the earth and let us know before we leave here. So,
absolutely. Sure.
Well, all right, then. I figured that was the case. But anyhow, Tim?
Well, as Galen said earlier, I want to welcome all of you, and I know several of you. We'll hope to get to know all of you. A few years back, we kind of started this scenario just to have a good communication dialogue with the engineers and their board, because we do share some similarities in things that we do. You all actually use surveyors, and we actually use engineers in our profession, so we have some overlap and so forth. So that's really why we want to do this, to stay in close communication. And like I say, we know a lot of you anyway. Again, thank you for being here. I just kind of had a question of curiosity for you all about QBS, sort of where you all are at on that right now, because we've been talking with our attorney again just as early as today again about QBS, and it's always good to understand where your all side of it is, because we feel like we're sort of in a parallel universe in a way. So, you know.
Prohibits professional engineers from submitting pricing for selection. TSPE and ACEC of Tennessee on educating and purchasing agents throughout the state. Haven't in a while, but John and I attended last year, I guess, conference of purchasing agents to address the topic, to alleviate any concerns that they would have, because traditionally purchasing agents feel better about bidding services on publicly funded projects, and we understood that, but we hopefully alleviated some of their concern in the context of them still having control during negotiation to arrive at a fee once a qualified firm or individual had been selected to do the design or whatever the project required. So I'm not aware of any major pushbacks from any stakeholder group. So, but we do understand it's a process, it's not an event, and we continue to discuss it and working that we're aware of so far. I don't know if Casey wants to.
I'll talk a little bit, Tim, because I also do surveying as well, and I think it's something that is let's start and be as transparent as we can, we don't have 100% success at QBS, okay? There are a lot of workarounds that some of these public entities have found to kind of go around QBS. Some of those are, when you look at design build, when you look at some of the different delivery methods, there are ways to kind of go around that. So I don't think you're ever going to have 100% success, right? So make sure you don't make that your goal. On the flip side of that, I think it is desperately something that you guys need to do to raise the level of your profession. I've seen several requests for proposal that do include a qualification, that are for surveying services that do require a qualification part to it. And I felt encouraged about that because all of you all know, and we can sit here and swap stories for hours of surveyors that we know of that we followed behind that should never have gotten a license in the beginning. And you may be able to tell some stories about engineers are the same way, but I think that's a critical part to what you all as a profession to survive and go forward with, and to give some confidence to your end user. I think that's critical. One of the things though that you're going to also see that we're kind of faced with on ours, we've had some real good success with how we've done our QBS as far as who the contract's between. So if it's between a public entity and an engineer, then you have to use that QBS process. That doesn't necessarily apply to that second tier. And we just talked about additional services, and this, you all are an additional service, right? Surveying, and I say you all, I mean we do it too, but surveying is an additional service, just as geotechnical is an additional service, and I'm sure there's some others I'm leaving out. Those things are competitively priced, not necessarily based on qualification, and I think that's kind of that's a real weakness in some of the system, is that you put together this qualification-based process, and then you don't require qualifications of the people that you're getting pricing from. And that's an industry issue more than I think it is a legislative issue. I think like I said, I think it's something that is a path I would go down. You all would probably have, you're going to have a tremendous learning curve, and you're going to have an education curve, as well as you're going to have, I would think, a ton of resistance from a lot of your surveyors, just because several have been, grandfathered, and some from as you all have stepped up your education, some of those are behind some of that. You run into, and here's where the kind of the big problems we run into in more of your rural areas, where you've got one person that's the surveyor, whatever, that in that rural area, and he's really the only one for 100 miles. We run into it on the engineering side, where you're the engineer, so you must know how to do this, and this, and that's not all. So I think it's a very worthwhile thing to go forward, understanding that you're on a journey that's not going to be through, and it's going to take you a long time to even get over the hump, I believe. But I think it's the right thing to do.
Bob, thank you very much for those comments. I think you hit the nail right on the head as to sort of our thoughts about where we're at with it. Again, it's trying to get the foot in the door. You got to start someplace, and obviously it is a good threshold for professionalism and a professional product. We've asked our attorney to craft a letter and send it to the AG to get an opinion as to whether or not we're actually included under that umbrella. Now, as Hal aptly said, you all are named as being under that umbrella. We think that we may be under that umbrella, but maybe we're clearly not named. So we want to see where that's at, to see whether or not it's necessary to maybe seek out a surveyor that's interested in it, that might want to get with a legislator and craft some legislation to try to get us on that ship, to get started on the journey that you've just so aptly described. So that's kind of where we're at on it. I can certainly see myself a lot of merit in it. I'm sure Jay can too, with a lot of the different entities that we do proposals with and things of that nature, larger entities. And you're exactly right. When you get to a rural county, we still have counties in the state of Tennessee that does not even have a licensed resident surveyor in it. When you talk about that, your situation is right on, because the next guy lives 2 counties over, and he always does everything for whatever the county seat is and the county. And we understand it, and it's not and as you all look at it too, it's not trying to eliminate anybody from doing work. It's just trying to up the level of professionalism, both for the profession and for the public.
And I think one of the things that has been somewhat successful, as we've talked to purchasing agents, to county officials, really part of this whole process, and a large part, is to minimize legacy costs that public entities may have from making selections of unqualified individuals. We can all point out to a school that was designed poorly by somebody who was not experienced, and their maintenance cost is doubled every year from where somebody. We can all go back to a property issue that was not vetted properly, that counties are having to settle for large sums of money to get that issue taken care of. And so I think that is where we've had some success in being able to try to tell them that by using qualified individuals, you hopefully get rid of some of these legacy issues that kind of chase. On the front end, they're very cheap, and on the back end, they're way, way, way more expensive than they should have been if done correctly.
CEC has a committee Business Practices Committee, that has spent a bunch of time on QBS this year. One of the things we're trying, because we're seeing so many loophole sort of situations, and there was a point in time this year where I was sending about 1 letter a week for an RFQ that was asking for price. And so we're trying to do it on 2 ends. One is how can we educate municipalities, particularly where they're smaller and they see a lot of turnover. We're going to start working with the new County Mayors Association exec, who Robert knows well, and some of those associations. But sometimes, and we're then also on the engineering end, going into our firms and possibly trying to be part of that safety conversation on the front end, just to educate the younger engineers coming in on how it is and why it works. Because how long have you all had that law? Since 13. There are a lot of people who don't even know what it is. So it takes a tremendous amount of education, and I think ongoing. So one of the pieces that we're trying to put together, there's several states, 5 or 6 that I know of, that have like QBS Ohio or whatever state it is, and we're trying to come up with kind of a coalition, so that when we do go out and educate, it's not us telling them what to do. It's sort of even if it's still one of us doing it, it's sort of a third separate tier of an entity that's really just there for that purpose. Probably 501c3 that has that ability to just educate. So there are a lot of moving parts on that.
And that's the key thing. So it doesn't look like that you're being self-serving by trying to protect your financial interests, and that education and continuous education, repetition. Robert's right, the workarounds are there, and the spirit of the law can be challenged, but it goes back to the owners and the owners' reps and the purchasing agents feeling like they still have some control. Part of that discussion.
I'll just reiterate what Mr. Lingerfeld said. I mean, I think it's clear what the desire and the goals and whatnot. When I look at the law, as I was explaining this morning, is I can't say that land surveyors are definitively included in construction services because, I think reasonably you could anticipate that, but the plain language of that statute does not list land surveyors, and so I cannot say that the intent is to include on the QBS or the QBS statute is definitively the intent is to include land surveyors, and so I think that puts us in an area that we need some clarification on, and certainly we will work to try to get that clarified and get an answer.
Right. So during the Southern Zone, you're going to hear presentations from different task forces and their recommendations. And one that I sat on was the use of technology in engineering and surveying. And we had kind of a related discussion in regard to how to define the model law to encourage the use of technology, but to protect the integrity of the professions that would be using them, even in regard to legal matters and financial ramifications of what we do. So you might hear when the presenter makes comments maybe and presents it, it might raise some consciousness for you relates to the law, and just again the importance of the design services of engineering and surveying and its impact not just on the actual work but to the local economy, the individual, their everyone. It can appeal to everyone, and everyone seems to understand that.
Anything else? It's open for discussion. We'll let all of you have a say about anything. Tell us what you think of surveying, whatever you don't think of surveying.
Are you going to go kind of, we've got this, is this the agenda?
There is an agenda for today.
Okay, well, we going to go down these things?
Okay,
I just want to make sure.
We are, and I'm sorry I didn't pull mine out here.
You're fine. I was sitting here kind of.
We kind of bounce around, Rob.
You're fine. I didn't want to go to number 5 if you all were going to.
Yeah.
But I don't know which one I'm going to. But
Yeah, just grab one and throw it, and we'll catch it. How's
I don't
that?
want to do that. It's not like I'm not the man with a big hammer.
Yeah, he's got a big hammer.
Yeah, they brought that to me this morning. But anyhow, as far as I'm concerned, yes, I'm looking at it, and I don't have the copy of my agenda in front of me. I copied it off, and I don't think I brought it. I brought everything else I needed, including down around stuff and what have you, and I thought it was all right here. But anyway, let's go, and let's take that agenda, and we'll just go through. Yes, all right. And we're looking at what? You're looking at new business there? Is that what?
Yes, sir.
Number 1, updates on the 2016 NCAAS zone meeting. We've already done all of that. Certification of the FEMA elevation certificate to engineers in Tennessee.
I want to kind of throw that one out. You know, FEMA allows engineers to certify elevation certificates. And I was just curious as to if you all on your board are see any problems with that as far as, any complaints or have any, issue with it, because it doesn't, and it's not that you can't do it, but in my mind, it doesn't seem to be a routine function of your practice. Let me say it that way. Tell you something that's happened just for your edification with the FEMA stuff. Most, I'm not going to say all, but most of the FIS profiles that you find on streams are based on recent years. FEMA has updated their maps, and they have changed those updates to 88. Well, you're now comparing apples and oranges. For example, in my area in East Tennessee, there's about a half a foot difference between those two datums, and 88 is half a foot lower. So effectively, if you use the firm map to determine your elevation and don't use the, if you use the GIS profile to determine your elevation, and then you go out and apply it with 88, technically you're a half a foot higher in my area, just to use a reference. You're going to be higher than what you should be. So this is one concern that a lot of people don't really understand about elevation certificates and flood analysis. And like you said, Hal, engineers do a lot of flood analysis. But it's something that FEMA has not done correctly. And you want to really be careful with that when you're doing one of those. And I don't know if you've experienced that same thing or not.
Is your board going to take on FEMA then? Is that your plan?
No, not even hardly.
That'll be fun to watch.
Yeah, no, not even hardly. But that was just one of the things I wanted to kind of throw out because
If your board has a statement or an observation or recommendation, we can certainly help get that message out, and I'm sure that Casey would entertain that as well. Advice or just a
as you well
notice
know,
of correction or whatever you want to call it.
oftentimes when you get dealing with elevations relative to flood, an inch or two or a tenth or two is very critical in whether the project works.
It affected a lot of Davidson County.
I think you'll find that some of that very impact is the very thing that I'm talking about, is the lack of apples and oranges not being the same. And because we're seeing it on elevation stuff that I'm working with. And
because I deal with those things here in Davidson County. I just did one yesterday and that kind of thing. But one of the things that I guess, and maybe you are attuned to this, Hal, and and where this came from, and I don't disagree with it, but a lot of times when I turn in a site plan and they're asking for an elevation certificate to go along with that site plan, they want, obviously, your base flood elevation and everything else you have has to be the same datum. And a lot of times when we get through with it, it isn't, so you have to go and convert the thing. Of course, around Middle Tennessee here, it's very minuscule for the most part unless you go out toward Cool Springs. So, and I'm not by any stretch of the imagination a GPS guru, and I'm sure there are others that are, but it does seem that as minuscule as it might be worth FEMA sometimes making these changes for us instead of us having to come along and do something that we are less familiar with. And of course, we use the conversion factor that they provide for us. And I guess you won't use that over in East Tennessee, but still, that's one of the things. Maybe, like you said, if we had a statement that we wanted to formulate, might be worth doing that kind of thing. I don't know. I don't know what help that would do. I'm like Tim. I don't want to take on FEMA, and neither does Jay or anybody else. I don't think here, but I do think that sometimes FEMA is they're just a half a step behind. I mean, that's just my opinion about the thing.
If you're interested, I can get you in.
Steve Fitzhugh, I mean, what it is?
It's Roger Lindsay or.
Oh, yeah, I know Roger. Yeah, in fact, I went to his office on one of these very things and sat down and talked with him about it.
Very credentialed, so again, if it's a topic.
you know that FEMA will make the proper modifications to things and present you with the right documentation if someone, for example, like a Metro Nashville or something, petitioned them about this issue. They will do that, but it's as I understand, it's a case-by-case basis.
something worth taking a look at. I'm not sure. I'll have to talk with our local chapter of surveyors here, because sometimes they get crossways with let's say the guys in the planning area, and it all has to deal with minuscule things. And I'm not saying that a tenth of a foot's not minuscule. Major in some places, and here, well, I haven't run across that. But anyway, all right, next we have on the agenda here is the possible new identification for surveyors in Tennessee and nationwide in the professional surveyors. Mr. Lingerfeld?
Oh, he's gonna look to me to talk that, isn't he? Well, all I'm gonna say about that is, if you address an engineer, basically, most volumes as to, what kind of professional you are. Now, obviously, some people use SE and double E and ME and some, CE, they use other things, but primarily it's PE. And I know in the surveyors forum that I'm gonna conduct over here this weekend, we're gonna be talking about this very thing. Because as you go across all the jurisdictions that NCAAS deals with, we as surveyors are called everything. Probably aptly so, but we have a lot of letters after our name, okay? And part of this, like this task force you mentioned earlier, Hal, and that's part of that also, is to try to see if we can't come up with a more uniform identity across the United States. And obviously, one of our greatest Achilles heels is that different from an engineer who basically the primary basis of getting there is your education. Different, we have all sorts of venues of how people become surveyors. And that's going to be one of the major things that we're going to have to get fixed over time. But we're looking at trying to come up with some kind of connotation. For example, just to use one, I have no idea if that's what it'll shake out to be, but just, PS. Just like you're a P, we could be a PS. But wherever you went across the United States, people would understand what that meant, Just like, if you're an attorney at law, never did figure out what the at law part was. But if you're an attorney, everybody knows you're an attorney. So, just like a medical doctor, you're an MD. And that's part of the professional personification that we're trying to upgrade who we are and what we do to that level. And because of the many different avenues of getting there, over time, we've had people who got grandfathered in, all sorts of things. It just takes time to flesh all that out to get to where we want to go. But we've got to take baby steps to get there, and we've waited too long to kind of get out of the stroller and start walking. So we've got to get moving. So that's the reason that was brought up, just for y'all's kind of edification, because it may appear probably hopefully within a year or so before the council, and be a motion of sorts to change model laws and model rules. So we want to just kind of throw that out just for your awareness.
Okay. Now, I'm a pilot, but I haven't flown the UAV, but please feel free to address. Drives them.
Well, we got our first one the other day. We have a license. Actually, I've got a licensed pilot on staff, but I'm getting my license coming from the FAA fairly soon. I think this whole industry is very. How we collect data has. I told a surveying class one time. I said up until about 15 years ago, we surveyed basically the same way the Egyptians did 2,000 years ago, with angles and distances. Now with GPS, I mean, within my brief career, we've had GPS, we've had LiDAR, now we're drones. So we've had almost 3 shifts of the way you collect survey data from 2,000 years ago.
Traditional to the modern, right?
Yeah, and it's going to be even more important because now survey data has always been collected in 2 dimensions. Even though I know you do X, Y, and Z, but it's always been presented in 2 dimensions, and now the world is a 3-dimensional, 4-dimensional, in some cases 5-dimensional world when you start looking at building information models that you have, Revit models. There are now model delivery systems that you turn over your surfaces, both your beginning surface and your design surface, and turn those over to contractors now to go construct things. They use GPS, machine controllers. And so I think this whole thing about data and how we collect it and how it's disseminated is a huge deal for both of our boards, because at some point in time we're going to be asked to stamp models. How do you do that?
The task force has recommendations.
Right, but I mean, and how you collect that mass data, because typically we're not talking about property line information. Property information is augmented, but who can collect it? What kind of quality control do you go through to make sure that it matches NAD 88 or how do you do that? And what I think is a big deal. I still think, again, we've got surveyors on staff, so it doesn't bother me as much, and I turn that stuff over to them. The drone can be used by somebody that's not a surveyor to go out and collect data to design something from if property information is not required. So, and we have architects now that are measuring buildings. So, you know, to put that in Revit, so what's the difference? I mean, on some level, but.
Most interesting topic, I'll tell you that, so. I don't know, your firm you don't have drones yet, do you?
Not yet, but we are throwing some feelers out there.
Okay. And you all have acquired one.
Got one, and we've flown it around outside a bunch, and we know how to use it, but we're not officially, until we get that license in our hand, we're not gonna go out and really go crazy yet. But yeah, I mean, we kind of understand what we're doing with it.
I know that I've talked to a surveyor down in Murfreesboro that's been talking contract with Story and what have you, and he is not licensed, but he does have a drone. And I'm not sure what it is. I have guess probably more than you do what's going to happen with the data that our guys would collect, because I think it could be that we're staring it in the face and we just haven't we're seeing the forest but can't see the trees. So
it's kind of a companion topic to the qualification-based
yes.
selection, because as we all are discovering, the regulation and the use of technology is not keeping up with the development of the technology. And unfortunately, as technology's advanced and made things easier, it's also made it more accessible. Better or faster or whatever, and I think that's a challenge for all design professionals, and so it's something I think that value. The technology can be used to devalue the importance of licensure and registration.
This whole subject matter goes directly to the core of both our boards' charge of protecting the public safety, health, and welfare. And, you know, and right, Hal, we've got to wrap our arms around it. I'll give you a good example. There was a piece of legislation, and Casey may want to speak on it maybe, but there was a piece of legislation that was on the Hill that was introduced by a representative, worked with TDOT and so forth, and ASPRS, did I say that right?
Yep, that's right.
Worked with ASPRS, the photogrammetrist group, and had a good piece of legislation, yet there was a local legislator here in Nashville that decided to attack it vehemently in the meeting, and he attacked it on the basis of if you were flying this parking lot, for example, out here to do a topo or something of it with a drone, his angle was if there was a woman out there being attacked by a man and you happened to get that image, then, you know, we got a problem. Well, that's not what you were doing, but it's something, a consequence that happened, and I may not describe it as aptly so, because Casey's a much better
That was
speaker than I am.
almost exactly the conversation
And
that happened in the committee. So TDOT, when TDOT has in their grand station or whatever, where they're taking all the footage all over the state, they cannot, the courts can't use that footage for anything. Like that is, they have some special regulation for that. And so the issue was social media, people's privacy, innocent until proven guilty in that particular conversation. But what I thought was really the important piece that has come out of that drone, oh, you know what? My phone's broken and I'm BlackBerry, and I haven't had one of those in like 15 years. Sorry. I have no idea what to do with it.
Really? Wow.
I'm borrowing it until my phone comes.
Sorry, Casey.
But what's come out of that there were 2 drone bills this year that were important. One of them has morphed into really an educational use and really training people on them, et cetera, in some of the schools. But the big drone bill that I had a lot of concern about at the beginning, and it was talking about critical infrastructure, and what that meant was it was that you couldn't take a drone within 250 feet of critical infrastructure. And as the bill was written at the beginning, that meant petroleum plants and things like that. But it's so easy to get things amended incorrectly on the floor of a committee, and so I had some concerns about that. Thankfully, our concerns were identical to those of Google and Amazon, and so our concerns were built in there, and so now the way that the bill reads as it was passed, because the piece that they were discussing about the guy in the backyard is a legal issue that I think became inconsequential, although it was a lot of discussion. But now that FAA designation is really important. So now you can no longer have the guy just throwing it up in a crowd of people taking, and I believe that the FAA's laws, ACC's working with the FAA on the new drone. There's a new drone law that will have some, I don't know if it has purpose written in there somewhere, but I think the goal is just to not have kids out there running drones all over, look in people's backyards and that kind of stuff. The other bill that I just want to mention, because we were talking about the professionalism piece, and I am concerned about it for the surveyors. The Right to Work Act, have you been following that? So I was fighting it until yesterday. There were only 2 bills in our committee, and I decided that I needed them on the other. More importantly, but the Americans for Prosperity have brought this bill, and they're very open about this is their bill. But they've got licensing bills going in all around the country, and this is the version that we have gotten this year. And they are trying to make it easier for people to get licensed to do things. And the way the bill reads as of yesterday, in the version that has passed to go to the, it's going through one other committee, I think, on the House side. It's got to go to Government Ops, which I think is its 3rd committee now. But they are going to test the licensing boards are going to have to justify every year what requirements they require, and are they too strict? Are you making, and the example he used yesterday, the legislator carrying it yesterday, the example was, does the class to learn to do that cost money? So, I mean, there's a goal here. Cosmetology was the example they kept using. However, it's going to come to everyone. And I think from I don't know very much about your board, and I'm new. I've been here a year now, so I shouldn't say that I'm that new anymore, but I really am. I feel fairly confident that they've pulled all of healthcare out of that bill. I'm going to try my best this week to get us pulled out of it as well. But I just think you ought to know, the more you can focus on the professionalism of what you're doing, should that bill really have some weight, and if it doesn't happen this year, they're going to keep coming back, you're going to have to be able to prove that you've got those steps in place, I think. Drone stuff coming up, I think drone drivers, or whatever they become called, and what they're allowed to do, I think will be another profession.
Well, and I think right now, if you look at it, there's certain things for a surveyor, you're allowed right of entry if it's germane to the project that you're working on. And I think that similar language has to be applied to drones. I mean, and I don't know how this would relate if I walk into somebody's backyard to get an iron pin that's, just happens to be on the backside of a fence and somebody's in there committing a crime. What my human reaction is, I stop them from doing that, I would hope. And but with a drone, you're kind of after the fact looking at that. But I still think that the ability to have a right of entry to make sure that you get the data necessary to perform the tasks that you're doing is something that still needs to be in any drone legislation that we have going forward. Because it's no different than, you got a drone flying around collecting information instead of a guy standing there or girl with a survey instrument. So
it's really just watching the unintended consequences of the purpose, the intent of legislation, oftentimes that will keep you out from doing your job. That's not even why they're looking at it. It's just a piece that it's an unintended consequence of it. So.
And I would think that every law has unintended consequences that, on some level.
Always the pitfall of a new law. It comes out and it's 4 or 5 sentences, and you don't know all this history of what happened in committees and
right.
what the intent was and what it really means. But now it says what it says. And that's always
the intent doesn't matter
right.
Once it's a law.
Once it's a law, the intent doesn't matter. That's right.
Plain language is plain language, and that's what the courts will interpret. And if it's in there, they're going to assume the legislature did not intend for it to be in there.
And when you were talking about the legal opinion on surveyors, I can't wait for you to. I fight that battle a lot. I don't know if I half or whatever, but surveying is oftentimes that falls in that gray area that puts, and that's how I end up on the phone with attorneys, places asking questions about it. And
what do y'all think about drones?
Price is going down. Like most new technology, you know how that works. It goes way up and it comes down. I think it's something, as Hal said, we're behind on being able to wrap our arms around some level of regulating it in relation to the work product that one of our professionals can put out to the public. I talked earlier about we've got some situations with some of our GPS standards. It's have what we call some remote sensing in our standards of practice that could, in my mind, wrap its arms around drone technology and give us some level of teeth if we had a complaint against somebody. But at the same token, I think the discussion is right to point when you talk about we do need to better either incorporate or tie it with other parts of our rules and our statutes so that if there is a time, and there's definitely going to be, as soon as the FFA cuts it loose, we're going to have lots and lots of problems. And in fact, talking about it and sitting on our hands at the same time, and aggressive than what we've been to point, and time is getting short, because I don't believe it's going to be near as long as it has been for the FAA to pull the trigger and move forward, especially with that new federal legislation that Casey spoke about a while ago.
I can ask a stupid question for all the others in the state who may not be up on this. Is there a fear that non-licensed surveyors can, with the drone, provide surveying services? Is that
Go on the internet today, and
is that the fear?
You'll find quite a few sites. We just hadn't had the complaints come in on them just yet. I saw one just last week of a gentleman providing topography for projects.
But that still is, I guess, would be a rules violation, correct? I mean, is that, even though it's happening, do you have the rules in place that would say a licensed surveyor has to be the entity that provides that information, whether it's through a drone or Egyptian?
You bring up an interesting topic. We and I know Bob knows this for sure, but we as surveyors have these holes in what we do. For example, it's not uncommon to see an architect, somebody works for an architect out here with an instrument doing a topo on a parking lot or something, getting ready to build a building. We do regulate that, but we don't regulate it in that manner. Same token, there's a lot of, quote, engineering survey work that goes on that technically we regulate to a point, but we don't. So there's some holes, there's some voids out there that it would be nice if it was clearer. Some of the things that you all deal with engineering-wise are pretty clear. If you're disciplining an electrical engineer on a particular situation, he's got a pretty good domain that he's in, and there's not much gray area, I would think, or a mechanical or whatever. But, you may have more gray area in civil than any other area that you have. I don't know that, but that's an assumption on my part. But like I say, from a surveying standpoint, there's a lot of holes out there. There's a lot of people there's a lot of entities in this state that in effect regulate how we do our work. One to come to mind right off the top of my head is TDEC. They tell us how we do certain things. We have to do it in a certain manner for them to be able to deal with us. Yet it's our responsibility to do the product to what this board says and what these rules and regulations say we have to do. Another one is state planning. State planning, I think, overstepped their bounds, in my mind, with some of the rules and requirements that they ask us to do, because they don't correlate, and they should correlate, but they don't. But there's a lot of different entities out there that's got a piece of us, and that's unfortunate. So I don't know if I answered your question or not. Get on a soapbox sometimes.
Well, I think you described how engineers or architects, other design professionals might provide some surveying, but I guess what I was picking up on is it sounds like there's a fear that even the non-design professional can use a drone or get on a website and get the information they need
Right.
without hiring a surveyor. Is that?
Let me give you probably what I would say might be the best example to try to emulate where you're going.
Okay.
For many, many years in the state of Tennessee, the property assessors had maps that were basically black lines on white paper. And they basically attempted to show what your property looked like and my property and everybody's property and how they all fit into the grand scheme of things, okay? Well, now as technology has evolved, the new toy for the property assessors is an orthographic photo, which anybody in the public can look and say, hey, that's my house, and there's my neighbor's house. Look, my car's in the driveway, and this is the street where the kids go to school. They can recognize everything on that picture. Well, what the property assessors have done with that picture is they have now overlaid, via GIS methods, overlaid property lines on these pictures. These gentlemen can attest, I can't tell you how much work I get out of that, because where they put their property lines is through the middle of Hal's house. And I'm the neighbor to Hal, and I'm saying, like, I own half his house. I'm gonna get that surveyor out there, and I'm gonna get that line surveyed. Well, this is where I'm going with this, is in parallel with drones. I want to give you a very common sense example, because John and Jane Q. Public believe what that picture is. I don't care how many disclaimers you put on the bottom of it, because it come from the county property assessors. It's right.
Absolutely.
It's a picture, and I don't care how many disclaimers are at the bottom that says, you know, this doesn't represent your property lines, et cetera, da-da-da-da. They think it's right. Well, this is where we're going with drones. You get a guy that gets a drone, can figure out how to run the software, run the drone, go out here and topo the parking lot out here. Well, the next thing you know, they throw a property line on there where they think it is. They're not surveyors. They throw it on there. Well, they're hours now. When they put that boundary line on, they're hours. I mean, it's my opinion that this board, for example, we get a lot of questions about construction staking. Okay, if you go out here and you stake out a house on a piece of property, how are you going to locate that house? Don't you kind of need to know where the boundaries are, because you got setbacks and so forth? Well, when you deal with boundaries and you're not a surveyor, you're hours, in my opinion, because that's you know, that's the paramount word right up front in our definition, because we're supposed to be, quote, experts in measurement. And boundaries is one of those areas that we're supposed to be expert in measurements, even though we only render an opinion. So that's where I think we're going with drones, is we're going to this same picture that John and Jane Q. Public can really identify with, because it looks like something they can see and touch. It's a picture of their property. And now you put boundary lines on it and other things on it, and now you got a problem.
Are you guys finding evidence of the use of technology to happened yet?
I've not seen it on a legal description side. I've seen it from let's say a purchase real estate type side. I've seen it from that, yes.
The lending institutions would accept a
I'll give you an example.
licensed or registered land surveyors.
I'll give you an example. First American Title has developed a product that they will take an orthographic picture and they will superimpose property lines, easement lines, deed books and page, you know, all kinds of information on it. And some states, some jurisdictional boards have actually, you know, hit them with fines. They try to justify it as though it's an in-house work product just for their attorneys, so that their people know what to tell the lender. But, you know, when you look at it, if you get a chance to see it, and once you look at it, it looks like, acts like, smells like a survey in every form and fashion. Doesn't have a surveyor's stamp on it, doesn't have some of the certifications on it, but everything else about it, I mean, it's got a title block, I mean, the whole 9 yards. It's as legal looking as anything you'll ever put your eyes on. And, you know, we fight that product right now. And that's from a major title company in the United States, and there's not but about 3 or 4 of them now, to the best of my knowledge. Yeah, this is something that we're seeing that's becoming very problematic. I'm sure that in your all's world, that, you know, you've probably got people using a lot of Google Earth and all kinds of stuff for, and probably a whole lot of what I'd call dog and pony presentations to clients for this stuff.
I'm sorry, can I interject something, Mr. Chairman? I just want to make sure that I'm sorry, I'm going to ask your apologies for my profession and my paranoia, but I just want to be clear so that anybody that might listen to our tape, we're having a joint meeting basically between the A&E board and the Land Surveyors Board, and we're discussing issues, and I know many members are opining on both sides, but none of that should be determined by anybody listening. Shouldn't be able to say, well, the policy of or the opinion of the whole board is A, B, or C, because we're basically just discussing things, and we're not taking any formal actions. We're just exchanging ideas between the two boards. So I just wanted to be able to clarify that in case if anybody said, "Oh, the land surveyor board said this." Well, no, they discussed that, but there was no formal action or declaratory opinion made. So that's the legal disclaimer that I just wanted to interject.
That's good, because trust me, come tomorrow morning, there may be somebody that may call me and say, "Oh, I was watching the tape of the board meeting yesterday, and look, this is what y'all came up with."
Right.
And it's exactly what you say, but yes. So yes, it's a discussion session, and it's not a formulation session, so.
And one of the things too is, and I'm glad you said that too, but one of the things is we discuss this some more, that you look at data, one of the biggest competitors obviously going to be, that will be for surveyors, and probably at some time is Google, right? Because, you know, I can see a day where Google will go online and say, if you want to buy a map of downtown Nashville that is, quote, accurate to do design work on, you'll have that ability to do that. I can see that. I mean, they're collecting data on too many levels and building too many storage places and things for it. But one of the things that surveyors, I think that you all have to be the gatekeeper on is, just as you mentioned, your job is about measurement, and that's the problem. It's the problem of the data that you get from Google may be off 3, 4, 5, 10 feet, and people are making real life monetary decisions based on that data. Whereas a surveyor, one of their tasks is to take that measurement and assign error or spread error, you know, least squares adjustments and those kind of things to that data to minimize those differences. And in my world, that's where I would encourage surveyors to focus a lot of this discussion on, is the quality of data from those different things that they're collecting. Because there are times when we use a Google data set, just kind of see what's out there, right? I mean, we're drawing a line. I mean, I equate it to a TVA quad map. When we laid out interstates and cities with TVA quad maps that were no more accurate than the Google stuff that we have today, you know, from just because it was on such a scale. But we used that to start with, and then we progressed and refined that as we went through those processes. So I can certainly see a huge benefit to the person that wants to use a drone to go say, okay, well, I've got this parking lot, it's about this big. I might be off 2 or 3 feet, but who cares? Right now I'm just trying to see how the pieces will sort of fit on a preliminary scale. But when it comes time to doing any kind of real design, I would hope there would be a surveyor or some way that you all can say, that is quality data that I'm getting and being used, and it's gone through a process that surveyors normally go through to make sure that data is of high enough quality, and not necessarily focus on the technology. I mean, you've got LiDAR, again, you've got drones, you've got phones. I mean, right now phones are doing the some of this drone LiDAR scanning type stuff and using photographs to do that with. So, and I can see a time when you're going to have glasses that are going to do that too, and probably already are that I don't know about. But I would concentrate on how that data is. It's good data, it's quality data, and it's been vetted by a professional surveyor, licensed surveyor. The public has good data, and your property assessor example is right on, because that data has not been vetted in most cases by a professional surveyor. Some of the data they use has, because it's accurate shapes, but you know, some people think, well, I've got a rectangular piece of property and it doesn't depict the corner that was cut out of it or something, and that's really that gets to be in a lot of arguments and a lot of court cases because of a picture and not the data.
Surveyors should be involved in the GIS world, because they are. All GIS is a large cake with multiple layers, and it don't take much to get one layer a little twisted or a little shifted, and it messes up the whole cake. I mean, that's my easy way of describing GIS.
Okay, I think that we've covered the other topics in here. Is there anything else that we would like to bring? Discussion on issues impacting engineers and the surveying profession. We've talked issues, but how about some other things? Anything else? Nothing? Well. Floors apart and what have you, but in other places too, and wish you the best. You can always apply to come back on the board. You know, somebody would probably want to put you back on there. I'm at retirement age. I'm not going to probably go for the the next session on here, but there again, glad to. Best. Maybe you can head the task force. They'll assign you to work these.
My dad used to say, you can become an expert around here quicker than anything. Just because I say the word drone doesn't mean I'm an expert.
Well,
How to spell it.
yeah, right, okay. As far as the surveyors, anything else we need to add?
Take a break and go out there and shake her hand.
In that case, Tim said it's time to break, but we do want to come shake your hands, and there's a reason for the break, so you know what that is. So we're going to come over and say howdy, and this meeting with you all at this time is adjourned. Thanks.
Oh, no, I just have our.
Thank you, sir. Appreciate the opportunity.
Good to see you.
Galen, yeah, good to see you. Yeah.
See you tonight.
Yes, sir.
Thank you very much.
Nice. Look, we're finally gonna be recognizable at the NCES meeting. I can't wear them. I can't wear them because Jay don't like let us wear orange. How are you doing, Tim? Thank you.
You're very welcome. Appreciate you. I'll come that way. It's been fun. You're very fun. Like I said, we'll see how this goes. Have to overlay it properly. He was celebrating.
No more, not anymore.
Did you see me? Oh. He's got eyes in the back.
Somebody does actually read those things.
I am glad to know somebody.
Yeah.
Let me show you what, let me show you what we got. This is what we got from him. We've got Drew and Claire, like agricultural consultant.
I got you.
And it needs that, and Peter, so we.
It does, it stops. Because we were asking, I was.
Heading that way. Be careful. Thank you, thank you.
Spencer Green.
Letter, right?
That's correct. He has,
From Senator somebody.
yeah, he has already had an appeal, so I don't know.
The appeal. Appeal the appeal?
What's LS?
Go ahead and knock it out.
We'll do it any way. We're here to serve.
Is this one empty? No, it's not. Get wait for
Parrish?
You can start Luffman.
Yeah, let's do it.
It's,
She gave you a card. Good deal. I hold on to it?
yes, you may.
Excellent.
That's,
Luffman.
I got it specific for you because
Luffman.
you're kind of the bird dog on this stuff. Better person than I know that she could contact.
Kentucky's invading us.
Hey,
Hey, really, what's up with
That'll be
Kentucky
a
coming
quota
down
on
here?
Kentucky.
Yeah, and we try to tell them we
Apparently
can't
the word
license
has
no
gotten
more.
out. Come on down
We
to
can't
Tennessee
license no
somewhere.
more.
Well, I've heard
Kentucky.
that before.
There's nothing too incriminating. So-
Whoops.
Bad about nobody.
Bumpus Mills. I know where Bumpus Mills is.
Note that on this application, it kind of caught my eye. Have you ever been denied licensure in another state? And he says yes. I remember him.
Huh?
I remember him.
Mr. Luffman, he previously applied in Tennessee, actually. I think in the year 2007. On the very first sheet.
Right under the 10-year rule, though, didn't he? 10 years. Yeah, he did. The high school plus experience. A lot of work into it.
Yeah.
You want to tell him that?
I do want to
Oh,
tell
okay.
him that.
Please speak into the microphone.
Speak into the microphone, and he not only coordinated them on the iPads, but put them on the projector for everybody.
He's on it.
So
He's on it.
he's on it.
What's wrong with them?
So I'm gonna have to
Oh,
keep. I'm
to
gonna
a
have
point.
to keep him.
He said it would have went a lot smoother if you'd have helped him.
It would have.
Not
I
put
did it
words in
last
your
time.
mouth.
It was
The Fifth
a complete
Amendment.
shambles.
Need to-
So, you know. 50 of them last time.
Yeah, that's right. Well, very first title look at's not stamped.
How many plants do they have there? Two.
Second one. There it is. I found it. I finally found it. Yeah, I finally found it. It's down here.
They're not stamped, or they're not signed.
Mine on here got a signature on it.
Oh, it is?
Yeah.
Oh, I got a second sheet here. Hold on.
I bet he didn't get a paper copy, did you? He probably send you a PDF?
Yeah, those could very well be the, But I've got them on the pad, and they appear to be signed over the stamp, signed and dated.
He put his certification in his notes. You gotta look all over the plat to find everything that you're looking
I
for.
was trying to find the certification.
It's in note number 20. Mine's different on here. Mine is signed and The red is just for his protection should that plat get released. Certification that we're looking for is actually up in, this one up in note 20 right above where it says see it there, Cody?
Yeah.
Hit in the notes, it's there.
That's where the biggest issue, and looks like that's taken care of.
My son's bad about that.
Well, I normally refold them myself.
I used to give him, when he was a kid, I used to give him a road map, and it would come back in the awful shape that it was. Road maps are like flood maps, they've sort of got an accordion nature to them.
You gotta work with them.
And he'd do this, he'd work with it, it'd be all wadded up, he'd throw it at me, here, Dad, you fix it. I said, okay, son, no problem. Then I'd fix it, and he said, I hate you. And it could be
Got
paid.
5 in the parish.
Morris to go, is that right?
Yeah, Morris is,
Morris,
I believe he's PLSIT.
he is. Morris.
License.
There's nothing I can do.
We could have maybe, like,
Local boy works at Reagan Smith.
I looked at it
Sounds
like
like
a million.
Well, that ain't worth a hoot.
Well, we can scratch him right off the bat.
Yeah, it looks like he was previous.
Crunch.
Supervisor,
That's trouble.
that's problematic. Reference too, Kevin Bridwell.
9:30, good gosh.
Woulda, coulda, shoulda.
In 2002, I think he just lacked the experience at that point, but now he's back, having hopefully completed it. Yeah, he's got. Yeah, he submitted much more education than he was required to at that.
from Tennessee State.
He's got an AS, he's got an AS from Nashville State. That's the only degree he's got.
We're left, but let's go ahead and do Parrish if we're ready to do that.
John Stevens, Representative John, or Senator John Stevens, and requested that he send a letter to our offices, which he did, requesting the board reconsider its previous decision to deny his application. I'll let you take a moment to read his letter. I don't want to paraphrase the senators. Mr. Parrish originally applied in December of 2014. He originally checked bachelor with 24 hours. As you can see from his transcript, however, he did have a bachelor's in surveying. He passed the fundamentals exam on July 26, 2014, which means he potentially could actually meet the requirements in another 3 months. So, my opinion that this should just wait until the end of July, as requirements should. I have sat with him, I've talked to him on the phone multiple times when Dawn and I looked at this originally, and we've communicated with him extensively in the past. I really haven't figured out any way other than how it reads exactly in the statute as to the 2 years progressive experience after the fundamentals exam. I certainly would, I'll let you know, open it up to the board's interpretation if you see any other way that we have communicated anything wrong to this applicant, but
I think we have two things here, Ms. Nicole. Number one is his degree is in agriculture engineering technology with a land surveying concentration.
Okay.
So just as a point of clarity, but it seems to me from our board, and I'm going to yield to Mr. Green or Ms. Martin, but from our board, I think that respectfully, we should respond to Senator Stevens's letter relative to the why as best we can. I think that that's what he does. We do something different. At the time that this gentleman completed his education, which was in 2011, basically by the law that was in place at that time, not the current law, it said that under a Category B, which would be what he was asking to be considered under, and the board made an interpretation on these categories. The category actually stipulates, it says you may have a Bachelor of Science degree from a science, engineering, or technology curriculum of 4 or more years related to the practice of surveying, approved by the board, plus an additional 24 semester hours of board-approved coursework in surveying sciences. Now, the board deviates from the way that that's worded as far as literal interpretation by simply saying that 24 hours during the curriculum is equivalent to 24 hours outside the curriculum. But pointing this out for Mr. Green's edification, because he may be the gentleman who has to help with the letter or write the letter. It further says passes 8-hour FS examination, which he has later done, and then it says submits evidence that such person has obtained a total of 2 years of progressive experience on surveying projects working under the supervision of a licensed land surveyor. Okay, from the time that, and this is where Mr. Stevens' letter comes in, or Senator Stevens' letter comes in, from the time that he got his PSLIT to when he wanted to take the examination, he had 2 years exactly of experience, and that situation, let me see. Passed his LSIT in July of 14. July of 14, okay? So even under the rule that was in place prior to the new change of how we do things, he still did not have 2 years of experience, and that was why we turned him down. My arithmetic's right, from July of 14 to when we looked at it the last time, which was February of 16, that's still not 2 years. So that was the reason that we turned it down. So coincidentally for this young man, the next available PS will be in October, and we go through his application and see nothing being deficient then October. And it's of my opinion that we have not delayed him any whatsoever, different from what the letter says. I don't feel like that all, I feel like he had surveying experience, but it wasn't to the level that it has to.
And that was under the rule as it was in place when
Prior
he
to
first.
2014, yes, sir.
Okay. And he originally applied in.
December 30th, 2014.
That was his first application?
Yes.
Okay, thank you.
And that was under the old. That was under the new.
Because the new law came into effect April 16th.
Okay. So that was under the new.
New law went in March of 14, is that right?
All had changed. Okay, we can draft
Now,
a,
in 3 months, anyway, he's gonna be.
okay. I'm clear. We'll work with Ms. Avers. And
Just a general FYI, it's really, and Jay and Galen may disagree, it's really hard to get the overall quality of experience day after you graduate to exactly 2 years. Typically, if you don't have any prior experience and you walk out of school and you go to work, and you may emulate this with an attorney, the same type of thing, associated with what you're going to be doing, and you kind of grow into it a little bit. So there's always a period of time in my mind from getting your diploma to kind of getting to where you're sort of up to speed, that now you're, from an employer standpoint, it's an investment time. You're making an investment, because if this person works through this period and they work out, then your investment that you've now made is going to begin to pay for itself, and they're going to be a productive professional from this point on. And that's part of, I think, in the analogy that was used in that letter that I read, I think that's part of that analogy was, it's just like it's, got my sheepskin up, I need to be moving on, pointed forward in licensure. That's kind of my take.
I'm gonna agree with it.
Always an individual that breaks the mold, that's a,
like me.
exactly like, yes, sir, just exactly like you. Laura said amen.
I guess the board would need to make a motion to that effect to respond in that.
Well, I agree with that, but should we not re-review his application just to make sure everything is in order? And then that way, when we make that motion, then
Absolutely.
we're good, and he's good, and everybody's sort of happy.
Okay.
Not all the way maybe, but sort of. Case, then he would need to submit.
Missing a year's worth of experience then.
Yeah, he would need to submit a new application, because that time interval is going to support our ultimate decision, in my mind.
Definitely. This is just really, it was just
Yeah.
the letter that was submitted, but I wanted to make sure I pulled the background history so that you had that with it.
Yeah, that's great.
Aye. Forms have changed even since then.
Ready, then I'd like to make a motion that we, and our attorneys craft a letter back to the senator and to the included in that request that the applicant submit a new application prior to July 15, so that we can give it final review, and if all things are what they should be, see no reason why it shouldn't be approved. And he's going for the FS, which means he has to have plats too.
One piece.
Okay.
According to what I see from the application, his 2 years wouldn't end until July
26th.
6. So if he submits his application before July 26th, are you going to deny it if you receive it?
I'm not.
I wanted to make sure.
We're
There's my-
shaking our heads
Yeah.
in the negative, we would not.
No,
So as long as, okay.
Or he feels abused over a couple of years.
All right,
No, that's fine. Good question.
I mean,
Good
he
question.
knows what it is, so.
Yeah. Take the exam until October anyway, so I mean, he's gonna have another 3-4 months.
Needed to resubmit for whatever reason, he still has ample time to
Yeah.
do that.
That exam only given certain times a year.
Right now, it's fixing, fixing to change.
Why not change?
Yeah.
all right.
See, it was a paper and pen exam, and that, but now it's getting ready to go to what they call open. Once they're approved to take it, they have an opportunity to take it.
That will still start in October.
A motion's on the floor, been seconded, discussed, and what have you. All in favor?
Aye.
Opposed? Okay. Takes care of that one. Next. Billy Joe.
Billy Joe. Jay has high ethical standards which are reflected in the survey data he education, Jay, there is 30 hours in that.
Yeah.
That would qualify. Proving what she said, so I did.
Next. Yep, I see it.
Brandon Suggs works for Huddleston.
Richard Sim is a principal in the company at Huddleston Steel. Wouldn't they have to have all the references? Well.
Our law says that you have to have,
All we've got.
plats, as we qualified him under high school because.
Gotcha.
He
Okay.
just
So
picked
we
a
need to
category.
change that
Yeah.
application.
He picked a category that he couldn't qualify under, but he could qualify under another category. Which, we got 5 categories. So we were trying to give the applicant the benefit of the doubt, and that's why we moved him into that category. We should have new plats now, hopefully.
That's what I'm. Arrived yet. They're not in the PDF.
He's applying for PS, so he's got plats in here that meet our standards.
And we're going to have him apply under that other method. Okay.
Make a motion that he amend his application and supply the plats that he's supposed to supply.
Do what?
This is it.
This is it.
IT hit? That's what Uncle Ralph always said, IT hit.
We've got a PLSIT.
Martin, Tennessee. There you go, Jay. Finally got one in your end.
West side.
Finally got you on the west side.
That's where all my family's from.
Really?
Martin.
Paris, Tennessee. This old Tommy.
That Summit fan then.
Oh.
Seeing as her name's all over the floor.
Absolutely.
We are too.
Pretty much covers the state.
Yeah. And then some.
Hey, Mr. Green, just for, Jay was talking about numbers. Apply today, when this application comes before this board, I get the I never decide to take the test. That's my number forever. It's also my license number. That's the way the system works now. The way the system used to work, for whatever it's worth, was from 1 to 500-ish, those were grandfathered in 1960. There up to approximately 1,100. 1,100 to about 1,400 plus or minus. In 1979, there was another law that came about that allowed us to grandfather engineers in that said they were doing surveying, so we could totally become separate from engineers. And then from is the NCAAS exams didn't if you got licensed before then, you could have been grandfathered or examined totally. This board in the beginning actually used to write, take the test up on the hill, the board members would be there at the test. And then after the test, one of them would take all of them home and grade it. They'd mail it to their buddy. They'd grade it, mail it to the other buddy, and then at the next board meeting, they would meet and go over the results and decide who got licensed. We've come a long way.
Yeah, absolutely. How many folks are in that pre-1969 license still practicing?
From 1 to 500?
There's still some, but
I would say probably not over 10%.
I was gonna say, I thought it might have been.
Probably
20,
less than 10%.
maybe.
I've come across very few.
Because they're dying out. Like my partner was license number 113, and he passed away in December of 14. What was?
My dad was number 31.
Your dad?
He went to the courthouse and bought his license. That's when I was little.
But that's just a little history for
Yeah,
you.
no,
Whatever
that's
that's worth.
That's interesting.
Whatever that's worth. And then in 2004 was when we had our last license, or our previous to this one, licensing law change, which we went to full BS. And there was a paragraph included in that licensing law that put us in the shoes we were today, that shouldn't have been in there. Talked about 10 years' experience, and what they were trying to say was, if you had that before the BS went in, then you could get in the window, but they didn't put the, what do you call it, the sunset date with it?
Right.
They didn't put the date with it.
And so it just went on and
It just kept going on, and we
Yeah.
kept fighting it and battling it and fighting it and battling it, and then we had a couple of folks that decided to get with their legislator and try to run some legislation, and so that's how this new.
that got changed, but just recently, right?
14.
Yeah.
It changed to 14. Really a step backwards in my mind. It really was. But we're dealing with it and moving forward. That's what we're charged to do, and we'll do it.
Did
What's the
you
experience
look at?
Winstead, yes, I'm good. There's your pen back, sir.
Thank you very much.
Rid of the game on some of them.
Yeah.
That concludes all of the business that we had to bring forward, so that brings us to new business on the agenda.
Yeah, do.
I'd like to make a motion that for all the applications that we have approved, that we formally approve them by the.
Opposed? Those that we disapprove, we. Business. Got any new business?
Do we have it on an agenda there?
Should be the top item.
Sure, Cody.
There isn't any listed items, it's just if there is any new
Oh,
business.
okay, so there's not a link to it, okay.
There's,
Now I
it's
feel
an-
foolish.
Items. Uh-huh.
It don't like to scrunch down. There it is.
That's the same thing I have here.
Where did we get to last time? It was so late in the meeting.
everything we wanted to, you asked us to fix on the website. FAQs, all of the
Like I said, hopefully I'll get another. Newsletters are.
Licensees.
Yes.
And two, have been putting disciplinary actions that were finalized in it also. That's one of the big reasons that we have the newsletter is because the registrants wanted to know what we were doing discipline-wise to folks. I mean, you know, once it becomes public record.
And there is if the board wants to include it in their newsletter, at your discretion to do so. But just so that I may be telling you something you know, and if I am, I apologize. But there is a department disciplinary action report that goes out the 15th of every month that has broken down by.
You can pull it up on the website, but
Right.
but you got to look through funeral
The paying,
directors.
You got to scroll down and
appraisers,
go to
hairdressers,
right.
and everybody else.
But I can pull that information out, yeah. What I was gonna do was expand on the Donna article to about a half a page, put something about the zone conference, once it has occurred. Last page would be basically board, business, board related, would have all that kind of stuff on it.
The big thing is most of the licensees like to see who the new guys are with the license. They like to see what discipline's been going on. Passed away, you know, I mean, that's not a good thing, but because some of them don't hear about it, you know, and it's somebody they knew and they're on the other side of the state or whatever, that type of thing. Those are important things. And there's a lot of important things in there. You do a great job with it, but you know, those are things that would be good to keep them included.
Those are the first things I always look at when I.
Because you'd be surprised, the surveyor, for example, if we discipline a surveyor in Tennessee, and we fail to send it to the NCEES, then if a surveyor that's licensed in Tennessee, for example, gets the newsletter because they are licensed in Tennessee, but they perchance maybe are in Kentucky, and they see that John Doe was disciplined in Tennessee, well, then they can check with their board and see if their board even knew anything about it. So that's another avenue that we sort of help each other. So.
Yeah, I'm happy to do that.
I might have asked Mr. Green, I know this is all placed on him all of a sudden, so he's behind. Even if he was ahead, he's behind. But he's doing a great job. We were in the process of looking at our rules and going through them and trying to get it as best we could, because, as I said earlier, some were 60. Like those as a project to work, and of course, at your direction and purview on that. Because of some, legislative change or some departmental change or just general change that we need to do to keep up to speed, that would ultimately help both us and the department should we get in a situation or whatever.
Totally understand, and we will, Ms. Martin and I will certainly work together with you to try to, update where we need to. I think, coming out of today's meeting, the GPS standards certainly, that have been lingering and how we're going to address those, certainly high on the priority list. And so, but that certainly doesn't mean that, we should be looking at the other areas of the rules to make sure they're updated and applicable because one thing I have discovered in the brief time that I've really been involved with land surveyors is that I think your industry is technologically impacted at a much greater speed than say, other areas. And, so I think that gives a sense of the importance of reviewing and updating and working with the board to try to make sure we're meeting those new challenges. So we certainly will take that seriously and go forward.
And I know it's quite short notice, Ms. Martin, but I'd like to extend an invitation to you to come over to our with board members, and there'll be 18 different have you over there, and I think we can certainly get you into whatever seminar we need to. So,
We appreciate that, Mr. Lindenfeld. We really do, Mr. Chairman. Thank you.
Published before I leave. This is my blue book now. I have it, but this is the updated one with the last things that we had. Quicker the better, as far as I'm concerned, because every surveyor, when you go in their office,
We will, I know the assistant commissioner's been involved in that very directly, and I will talk to him about, the state contract is with LexisNexis, and I don't know the form in which, the agreement to publish is. And I know we've had other boards that certainly rely on manuals and books like that we've had discussions with. And so, that's kind of an administrative decision, but I'll make sure that that's passed along, and I know that Ms. Avers has and will, and we'll try to get some answer for you.
and that's fine, but obviously the rules. Other new business. One other thing. Next motion.
Yeah, thank you.